Harry Rhodes. And he only produced one last night.
The red one? Yeah. No. The actual one. I forgot one.
Hey, we're live.
I mean,
Hello, good morning.
Good morning.
Good morning. We're about to begin. Can you take your seats, please? Okay, can we get roll call, please?
Commissioner Kern, Commissioner Pavlik,
Here.
Commissioner Kelly,
Here.
Commissioner Caliendo,
Here.
Commissioner Scarborough,
Here.
Commissioner Burke,
Here.
Commissioner Brumfield, Commissioner Beatty,
Could we, excuse me, can we just please get quiet, please, so we can get through roll call? Thank you.
Commissioner Beatty,
Here.
Commissioner Sowers,
Here.
Leopold.
Thank you. I believe is Commissioner Kelly was here? Okay.
Yes, ma'am.
All right. Sorry. Okay. All right. If we can please stand for the opening prayer and pledge of allegiance.
Lord, we ask your guidance today as we consider matters that will affect the safety and welfare of many people in our county. Help us to listen with open minds to matters that are important before us and to act on matters that will benefit those who reside in our area. Keep our minds open and alert, our hearts compassionate, and our comments charitable. Amen.
Amen.
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The Zoning Commission of Palm Beach County has convened at 9 a.m. in the Vista Center, Ken Rogers Hearing Room, VC 1W47, 2300 North Jog Road, West Palm Beach, 33411, to consider applications for official zoning map amendments, plan developments, conditional uses, development order amendments, Type 2 variances, and other actions permitted by the Palm Beach County Unified Land Development Code, and to hear the recommendations of staff on these matters. The Commission takes final action regarding Class B conditional uses, subdivision variances, and Type 2 variances and issues advisory recommendations on accepting, rejecting, or modifying the recommendations of staff regarding other requests. The Board of County Commissioners of Palm Beach County will conduct a public hearing in the 6th floor Jane Thompson Memorial Chambers, 301 North Olive Avenue, West Palm Beach, 33401, at 9:30 a.m. on Thursday, February 24th, 2022, to take final action on the applications listed below regarding official zoning map amendments, rezoning, Class A conditional uses, requested uses, plan developments, development order amendments, waiver requests, and administrative inquiries. Zoning hearings are quasi-judicial in nature and must be conducted to afford all parties due process. The Board of County Commissioners has adopted procedures for conduct of quasi-judicial hearings to govern the conduct of such proceedings. The procedures include the following requirements. Any communication with commissioners which occurs outside the public hearing must be fully disclosed at the hearing. Applicants and persons attending the hearing may question commissioners regarding their disclosures. Such questions shall be limited solely to the disclosures made at the hearing or the written communications made a part of the record at the hearing. Any person representing a group or organization must provide documentation that the person representing the group has the actual authority to do so regarding the matter before the Commission. Any person who wishes to speak at the hearing will be sworn in and may be subject to cross-examination. The applicant and county staff may cross-examine witnesses. Any other persons attending the hearing may submit cross-examination questions, including follow-up questions to the chair who will conduct the examination. The scope of cross-examination is limited to the facts alleged by the witness in relation to the application. Public comment is encouraged, and all relevant information should be presented to the Commission in order that a fair and appropriate decision can be made. Do we have proof of publication?
Yes, Madam Chair.
Can I get a motion, please, to receive?
Move to receive and file.
Second.
So moved. We get an adoption of the minutes? Sorry, all in favor?
Aye.
Move to adopt the minutes as written.
Second.
All in favor?
Aye.
Aye.
Yes, swearing in, please.
Yes. Anyone wishing to testify at today's hearing, please rise to be sworn in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you.
Amendments to the agenda?
Okay. We do have amendments to the agenda that we have provided the commissioners. Item number 10, we've requested, which has to do with our annual organization and election of chair, that we move that to the March 3rd Zoning Commission hearing. Item number 4, we have amendments to several engineering conditions of approval. We also would like to add an amendment to a compliance condition number 1. Under that language, it talks about if there's deviations or violations and representations for variances, it goes to the Board of County Commissioners. It actually comes back to you guys. So we just need to replace Board of County Commissioners with Zoning Commission. And that will actually be on item number 4, as well as item number 5 relative to the variance. So we just have to fix the verbiage on the compliance condition number 1. We also have an addendum on item number 9, which is Sherbrooke Estates. There's an attachment on the amendments to the agenda that includes the outreach that the applicant has done for the proposed application. In addition, when we get to postponements agenda, item number 7, late yesterday we received a request to postpone the Cherry Road application, so we'll have the applicant come to the podium on that, and that would conclude our amendments to the agenda.
Wendy, I don't have a copy of the,
Amendments?
exactly, the amendments to the agenda. Anybody else, Mr. Crawford?
I
don't have it either.
I got it. You sure it's not there? Well, possible. Motion to adopt the amendments
As amended?
as amended.
I'll make a motion to adopt the
Need a
amendments as
second.
amended.
Second.
Okay. All those in favor?
Aye.
So moved.
Okay, so that was Commissioner Caliendo and Commissioner Sowers. Okay.
Yes.
Correct.
Any disclosures?
Yes, I have a disclosure on item number 9. I spoke to the agent.
Commissioner Kelly? Any disclosures?
No.
Yes, I also spoke to the agent on item 9, DOA 00418.
I had email communication with the agent from number 9, but we did not end up actually speaking.
None.
None.
Yes, I spoke to the agent on February 1st on item 9.
Any conflicts or recusals?
Okay. Hearing none.
Okay.
Okay, that will bring us to the postponement agenda. Item number 1, ZV SWCA 2020-00880, which is TRG Farms. The backup is on page 1 through 2. The recommendation is to postpone to Thursday, March 3rd, 2022. Can I have a motion?
Okay. We have a motion.
So moved.
Second.
All those in favor?
Aye.
Actually, did that include agenda item number 10 to postpone?
Just number 1.
Just number 1.
Just number 1. Oh, I thought it was 10.
Oh.
Item number 2, ZVABN CA 2021-00797, which is the Palm Elite Car Wash, found on page 3. The request is by staff is to postpone to March 3rd. For a motion.
So moved.
Second.
All those in favor?
Aye.
Page 3 of the agenda, item number 3, ZV 2020-02120, which is the Delray self-service storage. The applicant has requested more time again, so the motion is to postpone to March 3rd, 2022.
So moved.
Second.
All those in favor?
Aye.
Okay. Added to our delete, the agent had requested yesterday on Terry Road, 2021-1030, a motion to postpone to March 3rd, but if the applicant can come to the podium and state those circumstances.
Which agenda?
Good morning, Commissioners. For the record, Josh Nichols with Schmidt Nichols. Yes, we're requesting a 30-day
You need
postponement.
to speak up. Can't hear you.
Sorry about that. We're requesting a 30-day postponement to work with 2 of the other owners within the MUPD. We were notified late that they had sought some legal counsel, and so we're working through some items with them. I think we already have a meeting set for next week, so we're just working through some of those items, and we should be good to go in 30 days.
Okay.
Move to postpone for 30 days.
Second.
Agenda item number 7.
Second.
All in favor?
Aye.
Any opposed?
And on our delete, item number 10, to postpone our annual organization meeting and election of chair and vice chair to March 3rd as well.
So moved.
Second.
All in favor?
Aye.
Any opposed?
Okay, that ends the postponement agenda and brings us to page 4 on the consent agenda. Are there any items in which the board would like to pull from consent?
No?
Hearing none, may I move to adopt the consent agenda
Second.
It would be
as
with the-
approved, as approved,
As amended.
As amended.
as amended, not as approved.
Second.
Sorry.
Motion by Caliendo and seconded by Commissioner Beatty.
Yes.
All those in favor?
Aye.
Aye.
Any opposed? Okay.
Moving right along.
Okay.
That will bring us to item number 7, or page 7, item number 9 on our regular agenda. DOA 2021-00418, which is the Sherbrooke Estates. The request before the board is a development order amendment modifying the site plan, number of units, and adding access points. The staff report is found on page 231 through 338 with conditions on page 250 and 259. We do again have an addendum on our delete with some backup information. Staff is recommending approval of the request, and I will turn it over to the applicant to provide a summary.
Good morning. If you could give me just 1 second for setup, and we'll be ready to go. Thank you. Thank you. Good morning, Ken Tuma with Urban Design Studio. My address is 610 Clematis Street, West Palm Beach, Florida, 33401. I've been sworn in, Madam Chair. A couple housekeeping items before we get started today. First, we have our whole team assembled for today. We have our transportation engineer, Ms. Troutman is here. Our civil engineer, Mr. Schnars, is here. Our landscape architect and site planner, Ms. Tuma, is here. We also have our planner, Mr. Woosley's here, and representatives of Mattamy Homes. The item in front of you today is Sherbrooke Estates PUD. It is a golf course conversion. It's located on south of Hypoluxo Road on the east and west side of Lyons Road. The matter in front of you today, I normally like to come in front of you for golf course conversions when we have a homeowner association and we're working together as partners. Unfortunately, in this case, we're not working as, we don't have a working partner with the homeowner association. There's some ongoing title litigation that is a private matter between the developer, or it's between the buyer of the property, the seller of the property, and the homeowner association. That is a private title matter. It won't be part of the discussion today. But when you look at what we're proposing today, we're very consistent on what we've done on other golf course projects. We've used our experience from designing these communities and have correlated that to what you're going to see today. So I'm going to walk you through a presentation. It's going to take about 20 minutes, and I'm going to walk you through it through the Sherbrooke Estate Association. So here's the subject site on the screen in front of you. There's the mouse. The screen in front of you, Lantana Road, Hypoluxo Road, so south of Lantana on Lyons Road is the site. The site is 530 acres. It's the overall Sherbrooke Estates PUD. We're impacting or affecting 152 acres identified on the screen in front of you. That is the golf course. That golf course has been closed for 6 or 7 years now. We're focusing the development on the areas adjacent to Lyons Road. So those areas, there's the mouse. The areas are adjacent to Lyons Road. We're intending to redevelop those areas. We're proposing 282 residential units in that area. The remaining areas will be left as conservation, open space, and lake areas for tree preservations and stormwater management and general green space. The request that's in front of you today, as indicated by staff, is a development order amendment, and it is to modify the Sherbrooke Estate PUD master plan to add 282 residential units and add access points. Today, the site has 167 units approved on it. We're requesting to add an additional 282. The land use on the property is 2 dwelling units per acre. Just some brief history on the site. It was approved back in 1976 originally as a larger project. It was over 1,000 acres. It included what is now the communities of Bellagio and Villaggio. Those were later removed in the 1980s and then went through their own development order process and have their own density and intensity associated with them. And that as you travel through history, there's been many changes, small amendments along the way. In 2016, the golf course itself closed. In February of 2017, there was a fire. It's actually arson at the clubhouse, and the clubhouse is burned down. The golf course has been closed now again since 2016. In 2021, our client acquired put the property under contract, Mattamy Homes, who are here today, and had proceeded with the regulatory requirements to request the item that is in front of you to convert a portion of this project into residential housing. So just a quick travel through history, starting in 1975. On the left side, you can see where the lakes were developed. Lyons Road was not constructed yet. Traveling to 30 years ago of 1991, you can see the golf courses being developed, the homes being constructed. And then in 2009, the golf course opened and all the homes completed. Today, this is the existing condition of that golf course. That golf course is closed, as I said earlier, been closed for many years. The owner of the property has kept it at the code minimum requirement for keeping it the way it is as it looks today. So as part of our research, we went to the sheriff's office and kind of said, what's going on out there? Well, there's been a lot of reports of ATVs, homeless people, and suspicious vehicles throughout the community. So, but that is actually from the records of the...
Excuse me, please.
That's from the records of the sheriff's office.
Excuse me, please.
So,
Thank you.
Thank you. So the proposed master plan is 530 acres. That's the existing master plan, the area identified in red. The proposal is to revise it to add 282 units to make the overall project dense homes 449, or a project density of 0.85 dwelling units per acre. Ladies and gentlemen, the land use on this property and all the surrounding properties is 2 dwelling units per acre. Now, the affected area here on, this is the existing future land use, and what I want you to look at this screen is the land use just not on this property, but all the way to the turnpike, all the way to 441, going south, is 2 dwelling units per acre, and the densities surrounding that all equate to those 2 dwelling units per acre. This is the affected area master plan. It's 152 acres. We're requesting to revise that. As I said earlier, we're focusing our redevelopment. And I'm sorry, my thing's not working that great. We're requesting to do redevelopment in this area and in this area with homes. The balance of it will be left in open space, tree mitigation areas, and lakes. The overall density, I said earlier, is 0.85 on the entire project. So here is the proposed master plan in several colors on the screen. The area in yellow is the area to be redeveloped with housing. The area in blue are lake areas. The area in green are open space areas. As you can see, we thoughtfully place the development area along Lyons Road. There's no access internal to the community. The access is off of Lyons Road. The lake areas are used throughout the community and spread on those existing golf holes. So there will be stormwater management. The existing homes, Mr. Schnars is in the audience today. He is our civil engineer. The existing development drains through the golf course, and we will be constructing additional lake and storage areas in those golf course to support that water. And you'll note that the lakes are large and in places where they provide benefit to the community. So here's the proposed site plan itself. Pod C on the left-hand side of the screen. As you pull into the community, we're proposing 98 units. Of them, 35 are single-family lots. Those 35 single-family lots are 65 feet wide by 125 feet deep. We're proposing 63 zero-lot line homes. Those zero-lot line homes are 50 feet wide by 125 feet deep. So as you pull into the community, and I apologize, the mouse just doesn't want to work. As you pull into the community, there's a recreation center on the east side. There are focal points. There's tree preservation areas. There's residential homes as you wrap around, and the zero lot line homes here. And then over here are single family homes. On the right-hand side, or Pod D, are 184 units being proposed. 78 are zero lot lines, 50 by 125. 106 are townhomes, 24 feet wide. It's important to note that on the east side here, this is where the pest control facility is right here. There's it's called Protec. So in our access points, we are proposing a gated community on both sides. There will be a gate. There'll be the proper turnaround associated where the large arrows are. Where the smaller arrow is, that's an existing golf cart tunnel. It's been there for many years. We're going to convert that and use that as a pedestrian connection for our residents. So there will be a consistent pedestrian circulation system from the park sites located on the east side to the rec area on the west side, so the residents are connected to one another. The next slide is about tree preservation and relocation. We are saving a significant amount of trees. I'm only showing you the development area in this slide, but we are relocating and preserving trees in place. We have conditions from the Environmental Resource Management, which we received this morning, and other conditions that help preserve those trees. I'm going to walk you through the tree preservation. So basically, the first thing we did is we sent our survey out there and said, how many trees are out there that are in the requirement? Well, there are 2,924 trees on that site. Now, some of those trees aren't trees that you keep, right? You don't have an acacia, you don't have the other exotic trees. But of those, 1,477 trees are going to remain in place. Most of those are on those golf holes that we're not developing. We're leaving those in place. Then we're also relocating existing vegetation where we're building lakes, where we're building homes. 389 trees are remaining. And then we're mitigating 366 trees. So the total trees, based on the calculation, being preserved and mitigated and relocated is 2,799 out of that initial 2,924. And there are non-native trees on the site. Compatibility buffers, very important part of any time you do a golf course conversion. What is my relationship to the neighbors going to look like? How do I protect? How do I not adversely impact the neighbors? What does it look like? On the screen in front of you, on the left side, starting in the southwest corner of the site, here. The buffer being proposed is a 30-foot compatibility buffer. The 30-foot compatibility buffer, in 1 second, I want to make sure I get my notes. First thing, the code requirement for that area, there is no buffer required. 0 buffer required. Your staff, we had requested a 25-foot compatibility buffer. Your staff has given us a condition of a 30-foot compatibility buffer. But the truth is, the separation from the rear of those lots to the back of the homes goes somewhere between 33 feet and 55 feet, depending where you are. On the majority around that left-hand side or the west side, the separation or the buffer area is 50 feet. Now, there are a few pinch points along the way, but the buffer area is 50 feet wide. Within that buffer area, you will find canopy trees. You'll find pine and palm trees. You'll also find shrubs to help create that separation in that view block. I will also show you that on a visual impact analysis. This is the landscape buffer being proposed. I'm sorry. On the right-hand side, we're also doing the right-of-way buffers, the 20-foot required right-of-way buffers. On this side, gosh darn it. On this side, we're proposing a 10-foot incompatibility buffer. That 10-foot incompatibility buffer is required because the property to the east is a little more intense. So in that incompatibility buffer, we will be providing a wall, a 6-foot wall, trees and landscaping north of the lake adjacent to the townhomes all the way to the edge. And then on the north side, we'll be providing a 10-foot right-of-way buffer up there on the north side. A 10-foot right-of-way buffers because there's an existing road right-of-way or an existing access road there. We'll be providing the required 10-foot right-of-way buffer. Then we'll also be providing 15 feet compatibility buffers on the south side, and then adjacent to Lacuna, we'll be providing a 30-foot compatibility buffer. So we've met all the requirements of the compatibility buffers. Let me walk you through this in section. In section, the first one I'm going to walk through is Lacuna on the right-hand side, A on the north side, San Messina. This is the visual impact analysis, a requirement when you do a golf course. You can see the homes on the left-hand side is the existing homes at San Messina. You'll notice the 105-foot wide canal that separates them, and then you'll see the proposed homes in our community called Sherbrooke Estates, and then you'll notice that there's a 30-foot access easement and a 10-foot right-of-way easement, so a significant separation between the two. The next buffer, buffer B, is through Lacuna, this visual impact analysis on the right-hand side. So on the right-hand side is the Lacuna Country Club. On the left-hand side is the Sherbrooke Estates. You'll notice where the lakes have been located, 243-foot separation between the lots. On section D, or visual impact analysis D, going through the section of the adjacent residential area. On the left-hand side are the existing single-family homes. On the right-hand side are the proposed Sherbrooke Estates. You'll notice that we're proposing that open space track. It's actually a compatibility buffer and an open space track between 33 and 35 feet, or 33 and 55 feet all the way through around that entire area. Open space, very important item on a golf course conversion. Let me walk you through open space. Open space, the way the code works, you look at the open space on the overall project, and you're required to make sure that you don't reduce below the required amount of open space. So the first part is existing unaffected area, meaning the original development. The original development, the affected area, was 377 acres. We're not affecting that area at all, 377 acres. At the time when this was approved, the code was 35% open space. So if you figure that out, the 35% open space means we're required to have 132 acres of open space on the existing development. Ladies and gentlemen, the existing development has 201 acres of open space. It's 53%. We're not proposing any changes. It meets the code. In fact, it's above the code. On the affected area, meaning the area, the 152 acres that we're proposing to develop, the 152 acres, the required open space is 60.98. The code has changed since 1976. It used to be 35%. Today, it's 40%. 40% means we're proposed to have 60 acres. We're leaving in open space 104 acres, a total of 68.3%. We've met all the criteria of the open space requirements. Workforce housing. As part of the project, we're required to provide workforce housing. We are providing workforce housing in the townhomes. The proposal for the workforce housing, these will be built on site. Mattamy is committed to constructing them. We're not giving them to a community land trust. We're not buying them. Mattamy is going to build these on site, and they're going to be in those two lowest ranges on the screen. They will be delivered at $168,000 to $216,000. Traffic. As you know, you're required as a submittal, as part of Palm Beach County, to submit a traffic study. We have submitted a traffic study. Ms. Troutman is here. She can opine to its effectiveness. However, it meets the level of service as reviewed by your traffic engineer and submitted by our traffic engineer. Community outreach. I started my presentation saying that, unfortunately, we haven't been able to work with the homeowner association, but we have worked with the neighbors. We've had some neighbors talk to us and communicate to us. We've worked with the surrounding property owners. We have made ourselves available for anyone who wants to meet with us. On the screen in front of you is some highlights. First thing, as part of the code requirement, you have to send a certified letter. We sent a certified letter to all the residents and all the homes in Sherbrooke. We then the next day, we put another letter in the mail and said, hey, we want to have a virtual meeting. COVID was going on. And we had a virtual meeting with the residents of Sherbrooke or anyone who wanted to attend on March 2nd of 2021. We then sent emails and outreach to Sherbrooke and also the surrounding homeowner boards. We had the opportunity to meet with representatives of Bellagio and Lacuna. We listened to what they said. They gave us some good input, and we have modified the plan based on their input. We also have, from that point forward, as I mentioned earlier, we had the pending litigation. We have tried, as you can see, several letters. I think there were 7 letters sent to the HOA board requesting a meeting. None of those were responded to. We then held virtual meetings.
Excuse me. Could we just keep it down to there so we can hear him? Thank you.
Thank you, Madam Chair. And Madam Chair, I may need like 5 minutes more. I'm sorry. Thank you. Yes, ma'am, I'm going fast. All right. So we also had a ton of virtual community meetings open to anybody who wanted to attend. We sent mailers out to everyone. We sent emails out to anyone who wanted to come, and a lot of people did come. We also met people on site. On November 11th, we went to COBRA, to the Growth Management Committee, and gave our presentation to the Growth Management Committee. And I want to read exactly what COBRA responded to me about that so I don't get it wrong. COBRA sent me an email the following day and said, hi, Ken, at this time, we will not be providing any comment on the Sherbrooke proposal. COBRA is not opining on it one way or the other. Here are more virtual meetings, and here's just a summary of the outreach that our outreach team has done. Lots of phone calls, 3,000 letters mailed, 35,000 emails. They sent a team out there to go knock on everybody's door to come up with, and then we also hosted 33 meetings. There are letters of support, ladies and gentlemen. I'd like to submit to the record today 108 letters of support. The majority of them are from the surrounding communities. There are some from the residents within.
Excuse me, please. Excuse me, please. Could we please just refrain? I know this is an emotional, situation, but if we can just respect when somebody is speaking at the podium. Thank you.
Madam Chair, motion to receive and file.
All in favor?
Aye.
Any opposed? Okay, so moved.
I just added an additional document to that, but I just didn't hand the full one. So there are standards, ladies and gentlemen. That's your job today, the standards. And those standards are the standards identified within the code. And the first standard is it consistent with the comprehensive plan? The answer to that is absolutely yes. It has LR2 land use, meaning it has 2 dwelling units per acre. The proposed density on the entire site is 0.85. It is consistent with the comprehensive plan. Your staff has agreed with that analysis. And we also have the required workforce housing as required within the plan itself. The next part is consistency with the code. There are charts in your code that we have to meet. And first, I want to read from the staff report. The applicant has sufficiently demonstrated through the from the submitted plans, the justification statement, and supplemental reports that the proposed redevelopment of the golf course meets the requirements. It's consistent with the code. Here are some of those requirements in an effort for speed, Madam Chair. I'm going to zoom through these. We notified the homeowners. We didn't reduce the required open space. We prepared that visual analysis that I showed you earlier. The next set are the PUD design objectives. They are, is it designed predominantly residential? Yes. Does it have a continuous circulation system? As I identified about the walking trails and the ability to go through the tunnel, we have a continuous circulation system. Perimeter landscaping buffers, majority of them are not required. Zero landscape, we have provided landscape buffers. Established neighborhood character, the exemplary design standards create that character. Preserve the natural environment. We have worked with diligently on this project to come up with tree relocation plans. We've worked with your landscape division to relocate and save many trees on site. Does it minimize does it minimize potential adverse impacts? The buffers, the lakes, the open space, minimize those buffers identified in your staff report. Proximity to other uses, yes. Focal points, we have focal points throughout the community. Neighborhood park, yes, we meet that requirement. Decorative street lighting, yes, we meet that requirement. Decorative paving, we will have decorative paving, so we'll meet that requirement. Fountains, we will be above the code requirement for fountains. I believe the code is 1, we're at 5 or 6. Benches and play structures, yes, we meet that requirement. Interspersed housing, we meet the requirement. Pedestrian circulation systems identified earlier. I have 2 more slides and I'll be done. So very quickly, going back to those initial standards, these are the things that are in your code. There's 8 of them. Is it compatible with the surrounding uses? From your staff report, the existing development area is compatible with the surrounding residential communities in the area. The modification to convert the golf course to the residential development will continue to be compatible with the surrounding community based on the layout proposed through the revised master plan and the location of the open spaces. The next one is design minimizes adverse impact. Open space, the lake area, and all those items that I addressed a few minutes ago. Design minimizes environmental impact. The proposed use design minimizes the environmental impact. More specifically, from ERM, the tree preserve area, the water management tract, the open space have been located to maximize on-site preservation of native species while meeting all the other requirements. I'm not going to read you the rest. There are a lot of conditions of approval to keep this moving. Another item that may come up is site contamination. This is an old golf course, and we are required to submit to your environmental resource management a phase 2. We will do that. And if that phase 2 and the soil management system shows that there are contamination, we will follow all the requirements of the Florida Department of Environmental Protection. This is a true and tried system. We know how to do it. Our experts know how to resolve if there are any contamination issues. Are there adequate development patterns? The addition, this is from the staff report, the addition of single-family and zero-lot line and townhomes units along this corridor is consistent with development patterns in this area. Adequate public facilities, we have met all the criteria of adequate public facilities. Your engineering department has agreed, your traffic department has agreed, your health department has agreed, your fire protection, school capacity, we received a capacity letter, and the parks and recreation. Are there changed circumstances? This is my last talking point. Are there changed circumstances? Yes. The golf course has been closed. It's been closed for 7 years. The clubhouse is burnt down. It is in a situation where it is a changed circumstance. We have your staff recommendation of approval today. We have our whole team assembled, happy to answer any questions, and thank you for allowing me a few extra minutes, Madam Chair.
Thank you.
Yes, ma'am.
Staff?
Okay, we'll have staff come to the podium and do the presentation, and it is Iman Haddad.
Good morning. Good morning. This is Iman from Zoning Division. I'll be presenting the Sherbrooke Estate case. The 530.14 Sherbrooke Estate development is located within a low residential LLR future land use. and the Planned Unit Development PUD zoning district. The affected area consists of 152.45 acres. The site is located south of Lantana Road on the east and west side of Lyons Road. And the approved master plan currently shows 164 dwelling units in 3 residential pods. They're pods G, pods B, and A, as noted on the site plan. The applicant is proposing to convert the golf course use to residential uses for the development of 282 units, for a total of 449 units. Here on this slide, where I'm showing the affected portion of the affected area, Pod C. The residential Pod C is a total area of 60.52 acres with 98 proposed dwelling units, consisting of 35 single-family and 63 zero lot lines. The next slide here has shows some of the sections that the applicant submitted where the proposed additional or enhanced buffering is located at. Staff has included conditions requiring a 30-foot compatibility buffer along the north and west property lines, abutting the existing single-family homes within Pod G. So along where the Pod G is, where you see all those residential homes, there's additional buffering. Essentially, is that what that condition required? And then in addition to the larger buffering, staff also added a condition requiring additional pine trees. So instead of code requirement, we're asking them to provide all the required planting within the buffering and additional pine trees, 30 per linear feet. Pod D is a total area of 72.64 acres with 148 proposed dwelling units. 106 of those dwelling units will be townhomes, and the rest, 78, will be zero lot lines. Another slide showing where the additional buffering will be located at. Staff has added conditions to require a Type 2 compatibility buffer along the east property line of Pod D, where the proposed townhome units will be developed, approximately 700 feet. A 30-foot compatibility buffer along the east property line abutting the 7.95-acre lake tract, and the south approximately 1,700 feet to the northern corner of the lots. An additional 15-foot compatibility buffer along the south and east property line, abutting lots 20 to 23 and lots 26 there to the where you see the section G. In addition to all this, staff has also added a condition requiring additional planting material in those buffers. Additional canopy trees, palm trees, and pine trees within the 30 per 30 linear feet. I apologize. At the time of the publication, we received more than 80 contacts from the public. Concerns in general were around the increased density in the area, the impacts on the equestrian lifestyle of the community, concerns with proximity of the proposed development to existing developments, concerns regarding impacts to well water drainage and flooding, concerns regarding risk of damage to existing residences and lots during construction, and then concerns that there are an existing restrictive covenant with the golf course, and the concern is not addressed in the zoning, is not something that zoning staff reviews. just that last one. So the proposed application, per staff review, met all the ULDC requirements. Staff is recommending approval subject to conditions as indicated in Exhibit C. And with that, I conclude my presentation. If you have any questions, staff will be happy to respond. Thank you.
I have just one small correction on Pod D on the east property line where the townhouses are. We have a condition for a Type 3 incompatible buffer rather than a Type 2. The Type 3 is a minimum of 20 feet in width with a wall. So that's a Type 3, and it's in the staff report.
So the exact thing that before it just was addressed.
Yeah, she said Type 2. It should be Type 3.
Okay,
Yeah.
thank you.
Sorry, I meant to say Type 3.
Thank you. Okay.
Okay, so now if the board doesn't have any discussion for staff or the agent, you can turn it over to the public.
Okay.
I have some questions for the agent.
Did you have some questions? Okay. And there are also a number of engineers here as well, so I don't know if anybody has any questions as well. Go ahead.
I don't have any questions for staff. I do have questions for the agent.
Thank you, Mr. Kelly.
Thank you, Mr. Tuma. In your testimony, you said that there were a lot of vehicles or suspicious vehicles, and you had contacted the Palm Beach County Sheriff's Office. Did you do that by a public records request?
We did, yes, sir.
And can you define what a lot is?
I don't have it handy, but I will commit to you I will go back and look at it, sir. I don't have it right here.
Okay. I mean, less than 10?
Well, it's over a course of years from the time period.
Excuse me, please. Please.
It's over a course of years, and I'll pull that out for you, sir, but I could say that I'm trying to remember exactly how many. The ATVs.
I want you to be exact. I don't want you to.
I know.
If you need to refresh your memory,
I do. I will,
then
sir, of course.
We'll do that. And the golf course closed in 2016.
Yes, sir.
And you have the stats from the law enforcement agency from 2016 to present.
I will go double check them, sir.
Okay. I'll move on. I have just a few questions. I don't want to belabor this too much. On March 2nd, you said that approximately 60 residents, which according to my math is less than a third of Sherbrooke, participated in a Zoom meeting.
I'm not sure I gave an exact number, sir.
It said in the backup here, it says approximately 60.
Okay.
How long was that meeting?
Oh, hour and a half, 2 hours. I don't remember, sir.
Okay. And all of those 60 were from Sherbrooke, or they're from the surrounding communities as well, or was it an amalgam of them?
I need to go look to give you an exact answer. I will tell you that a majority of them were from Sherbrooke. That I'm sure of.
Okay. And I see there's a significant amount of attempts to make contact with folks. Did you guys ever attempt to attend a HOA meeting? I mean, I know you can send letters and you're making phone calls, but did anybody bother to try and attend a meeting and see these folks in person?
So in regards to that, how you typically do it, sir, is you request from the president and the board to attend a meeting, and we did do that.
Okay. And did you attend? Did anyone attend?
We weren't. They're private meetings.
Okay. So, in regards to the community that you guys have had difficulty, how many golf course developments has your company done?
Mattamy Homes, I'd have to ask them specifically, but I know of at least 2 that they've done, and maybe 3. I get that. And from a design standpoint, our office and the team here have done several of them.
Okay. And what's been in your experience, what is the typical response to this? I mean,
Sure.
I'm looking for what your typical response is to positive community engagement with the communities that are surrounding these developments.
Yes or no? Fair point. So typically what happens, and it's a process, right? No one likes a golf course going away in their backyard. There's no doubt about that. We all understand that. But typically what happens is we have a design process, as we work our way through. Okay, well, this lot's closer than this lot. Can you provide an additional buffer? Can you put lakes here? How could you put a fence here? Could you put a tree here? That's typically what we do when we work through the homeowner association. And also we work on other items such as road access and points. It takes a while, and it is a very, sometimes it starts out and completely on one end, and then at the end of them, as you've seen as board members, typically we come together with a solution. Unfortunately, we weren't able to do that here.
In looking at the volume of attempts, and there's a significant amount of attempts on the behalf of the developer to reach out to these folks. Did you guys ever submit a survey or a blind survey or an internet survey so folks could respond to, so you could perhaps gain that positive engagement with those people? I mean, obviously, it's not a requirement. I'm just looking for a way.
Mr. Kelly, yeah, of course.
I'm looking for a way for you folks as the developer designer to have a positive engagement with the people that are going to be neighbors to this development.
Sure. I'd like to check with the person who handled the survey. I know we did attempt one. I'm not sure what happened to it, so I just want to confirm that.
Okay.
I believe we used a Survey Monkey or something like that. But
I think that's where I'm going to. I wasn't going to specify a specific vendor or anything like that, but there are multiple platforms out there that you could utilize for that specific purpose.
Let me get the appropriate information.
Thank you.
Okay.
Okay, so thank you, Tyler. So Tyler reminded me we did both an email survey and a door-to-door survey.
Okay.
Neither got responses.
Nobody answered their door?
Excuse me, please. Excuse me, please. When you're at the podium, we will grant you the same respect. So please, thank you.
No, my question was, nobody answered the door?
Oh, no, that's not true. Let me get the gentleman who did.
Thank you.
Yes, sir. Mr. Arch here.
How you doing?
Yes, sir.
So we did go door to door. Unfortunately, no one was open to actually taking the survey. They did have conversations with the person who was canvassing, but they actually didn't give any responses to those. And there was also no responses to the email survey that we sent out as well.
Okay, thank you.
Thank you, Mr. Kelly, and I'll get you the response for the other matter, sir.
Thank you.
Yes, sir.
Yes, Mr. Tuma, do you have your civil engineer handy?
We do. Mr. Schnars is available.
Because I have a question for him.
Come forward, Mr. Schnars.
Morning.
Jeff Schnars, Schnars Engineering.
Morning. As far as my question has to do with the drainage and the lake configurations here, you've calculated that what they're showing is sufficient to pick up the new development and still continue to handle the existing residences adequately?
Yes, you'll see on the plan there's a significant addition to the lake area that was out there previously.
So you have added more lake. It looks like it almost
yes, they added more lake.
Less, but so you
Right.
have added based on everything around both sides of the road that you're adding to.
Correct.
What about, have you been in discussions with ERM as far as the development and the digging of these lakes, far as depth and required littoral shelf planting? Is there any requirements on your development for that?
There will be requirements. We will have to get a lake excavation permit from ERM. There will be littoral area requirements.
And have you calculated, this storm drainage is calculated with those littoral shelves in place? Because those are very shallow.
Yes, littoral shelves will be submerged, so they are part of the lake area.
They are, but they're very shallow.
Correct.
Right. So you have adequate storage without backing up and causing flooding.
Yes, correct.
Okay. Thank you very much.
Madam Chair, I have a question for the applicant. You briefly spun through the, I can't breathe there. You briefly brushed through the traffic study, saying that it meets requirements.
Yes, sir.
My concern is how it's going to flow between the communities that are there, and are there some traffic signal lights you're putting in, or so on? Because I know that's going to come up.
Yes.
Can you give a little more detail on the traffic flow and what, forgetting our requirements, what you're doing to meet not just the minimal, but meeting the future of what's coming through there?
Of course, thank you. I'm going to ask Ms. Troutman to come up and respond to that
Please.
question, but what I will let you know is that the amount of trips are very minimal, and it will not require a signal at the intersection that we're proposing to add. And let me put that back
Okay.
up on the screen, but Ms. Trautman will come up and address your other items, sir.
Please.
Good morning. Andrea Troutman with Pinder Troutman Consulting. The access for this site is directly to Lyons Road, so there is no internal access through other neighborhoods. There's an existing median opening on Lyons Road that has the left turn lanes and a right turn lane, so no additional lanes are needed. And the volume of traffic that is going through this intersection is not projected to meet any signal warrants.
Okay. Thank you. One last question in that regard. Does staff concur with what, does engineering concur with what they're doing with, about the future of the traffic flow through that area?
Yes, there are existing turn lanes. No additional turn lanes are required at their project entrances. They have just one project entrance on Lyons Road.
That's it?
That's it.
Okay, thank you.
If I could just tag team on that traffic issue, are you providing areas at the entrance for covered areas or something for children waiting on school buses? Did you address
The
that
answer is
in your
yes.
plan?
One to check with Wendy, but the answer is yes. They are proposed. They do meet the required turn radiuses, and there also are proposed bus stops, children's bus stops.
I have one more question on that, if you don't mind. On the stacking, is there going to be a guard at the gate, or is it just an automatic gates coming and going?
The gate system, I'm going to request Representative Manany get up. But typically, these gate systems are the fob-operated gates for a community of this size, and so. But it will be gated. The appropriate stacking, Ms. Troutman can confirm the testimony, but I'm sure we meet the requirements of the stacking.
Okay, so you more than meet the requirements on the stacking because of the turnaround that you would need if somebody makes a wrong turn there.
Yeah, there's a bailout lane. Yes, sir.
Okay, thank you.
Yeah. My question was geared as well with the school buses. Is it possible at all to illustrate there, kind of like where that would be, please?
Yes, ma'am. And I'll ask Ms. Tuma to come up here.
Thank you.
Make sure I do it in the right spot. But the answer is... Yeah. Right. The north side. Okay, so on page 20 of your board, on page 20, if I can get this stupid thing to work here. May I walk over there and point where they go?
Yes. That's
Okay,
fine.
thank you.
Yes, thank you.
Oh, actually, I've got a pointer right here. Thank you. One's there, and one is there. On the north side of the roundabout.
Okay.
It's right, I mean, more specifically, it's right, kind of like right there.
Oh.
And this one's kind of like right there.
Okay.
And it's identified on your plan set on page 20. They're actually called out in detail.
And are there sidewalks through the community proposed?
Yes, there are.
Okay. Any other questions at the current time from other commissioners?
I have a question.
Yep.
Yes, ma'am.
Just with regard to, you had talked about the pedestrian access within the new development. How is the existing development going to be impacted by this, and is there...
There is no pedestrian connection between the two, between the existing development and the proposed, and there's no vehicular connection between the pedestrian and the proposed.
Okay. And just one other question regarding schools. I believe I read that I think it was 91 additional student stations, perhaps something along those lines.
Can you use your mic?
Oh, I'm sorry. It's on, but I wasn't close enough. I'm sorry. Do I need to repeat any of that or no? I do? Okay. So my first question, Ken, was with regard to pedestrian access in the existing site versus the new proposed development. So you already answered it, but I had to repeat that. So
Understood, yes,
okay. And then the second question was just with regard to the impact on the schools.
Yes, I believe you're correct. 91 students are generated among the three age brackets: elementary, middle, and high school.
Okay. All right. Thank you.
And I just have a confirmation. None of the existing private litigation impacts this at all? You started with your presentation saying there was some existing litigation going on. None of that impacts this or will?
I will tell you, I'm not an attorney, but
Okay.
the county has taken the position that historically, and I'll let Mr. Banks respond on that, but this is a private title matter between private parties. It doesn't involve the county or the zoning, and historically the county's taken the position that this is I don't want to use the word irrelevant because it's relevant, but it's not a fact in the matter that's in front of you.
Is that correct, Wendy?
Yes, the
I
declaration.
know you're not a county attorney, but I know you know so much.
Or Bob can respond.
Bob, I didn't want to wake you there.
Yes.
He said it much more
Thanks, Bob.
eloquently than I did.
So eloquently said, Israel. Thank you.
Sorry about that.
Okay.
Question for Attorney Banks. Does the outcome of a decision in the courts, will that affect this process here?
We're going through a county approval process. The rights that are granted may be subject to private restrictions. If a person asserts they have the private restrictions, they'll enforce those in court and apparently are already doing that in litigation. So,
Thank you.
So just to follow up on that, just to clarification, so if a motion was to be passed in favor, and if the litigation was to go the other way, what happens? Because the process would have already started.
We don't supersede the courts.
So we don't have any,
No.
yeah.
Courts supersede us.
Okay, so we can, okay.
Sorry, I didn't mean to.
I mean, if a
No,
court
I just wanted to
determines some-
clarify because that was, because if it was, I just needed to, so if they're still litigating, and like they said, they weren't sure whether or not, can't say with all certainty if it would impact their decision there, but once we've already gone ahead and said, okay, approved it, what happens?
If ultimately someone is successful in private litigation, so someone can't use a development approval, they'll come back in and apply for something that meets whatever the courts determine, right?
Okay.
So at this point, it's really not relevant.
Jeez, rough.
Okay.
crowd.
Okay, all right, so if you just repeat quickly just what you said. They just couldn't hear what you had said. Your response, your final response.
They couldn't hear you, Bob. You need to repeat it.
The current proceeding is regarding the public restrictions on the property. If the private restrictions are adjudicated in court, so the developer can't utilize the approval if it's granted, then they'd have to seek a development order amendment to do whatever is allowed pursuant to a court ruling.
Okay.
Basically,
But
courts
we're dealing with the
supersede us.
current restrictions in the current zoning ordinance, and staff's following the rules, and we've faced kind of similar issues. This is, on prior golf course conversions, and we've seen litigation either against the county or private litigation, and if the county sued, it defends its suits. If there's private litigation, we just don't get involved.
Okay. All right. Thank you. Okay.
So that would turn it over for you to hear responses from the public. Typically, we have about 3 minutes, but it's at the discretion of the board. We have a lot of residents here on how much time you would allot them, as well as any representatives from the public that might be representing a group.
Okay, we do have a representative that requested additional time because he was making a formal presentation. Do I need to get a formal motion for that? Okay. All right, so I'm going to grant the gentleman, I think it was a gentleman, 15 minutes. That is a hard stop at 15 minutes, please. And any other people that wish to speak will be a 2-minute speak. Can you please state who it is you're representing? Because there are a number of...
If I may, I don't mean to go out of turn or anything. I'm John Jorgensen. I'm the attorney for the Homeowners Association of Sherbrooke. I need about 10 minutes. And with the board's approval, I'd like, if it's okay with Rupert here, to go first, just to make my 2 points. And then everyone else can talk about
Okay,
the
hold
other
just one
issues.
moment. Is this in addition to the gentleman that had, is this a separate request?
Yes.
Okay.
I'll be brief, 10 minutes max.
Okay, no, I'm going to hear the gentleman first that had the 15 minutes that we had approved. Okay.
That's fine.
The other requests, we do need to have you be speaking in behalf. I'd need the 10 cards, people that are giving up their time for you to speak, please. So if I can get the gentleman to the podium that requested the 15 minutes, and if you could state your name and address for the record in addition to who it is you're speaking on behalf of. Thank you.
Madam Chairman, members of the Zoning Commission, thank you very much for the opportunity. Can you hear me now? Okay. Madam Chairman, members of the Zoning Commission, thank you for the opportunity to speak before you today. I'm here to convey opposition
Can you
to this...
state your name, your address, name, address?
My name is Rupert Connor.
Thank you.
And I live in the subject neighborhood at 6652 East Calumet Circle. I have delivered a total of 114 resident petitions in opposition to this development, and of those, 94 authorized me to speak on their behalf. So why have so many neighbors asked me to speak on their behalf? Standing here before you nervously, I ask myself the same question. I love this neighborhood, and I fear that a gross injustice is about to occur that will deprive Palm Beach County of one of its finest, unique, and special neighborhoods. There goes the neighborhood was essentially the fear I heard from fellow neighbors and my homeowners association in early 2021 when news of this potential development of the Sherbrooke Golf Course broke. Everyone in the room was energized in opposition, but there were very few facts available on how to proceed. This is deed-restricted land. To regular people like me, if your deed says that something must remain a golf course, that's what it's going to be. Many here have purchased their homes with that fundamental understanding. We rely upon the county officials to support and protect those restrictions. What felt very odd about this situation was that zoning staff were working in cooperation with the developer to break our deed restrictions. This sounded so very wrong. I got hooked on the potential injustice, and I started to research. Palm Beach publishes lots of information on how to develop land here, but limited information on how to object to development. So I did what we all do and referred to Google for guidance. Google led me to land planners, traffic analysts, and environmental engineers from between here and Tallahassee. Most turned me down as their clients were developers or county staff, and they didn't want to be seen as anti-development. It became very clear very quickly that I was somewhat unique as an individual wishing to retain the services of an expert in objection to development. As I found answers, I shared them with members of the community, and quickly I became someone the community was relying on to appropriately voice our united opposition to this development. If Mattamy were building next door to Sherbrooke on a traditional rectangular lot, we wouldn't be here in objection. Our neighbors around Sherbrooke are all 2 homes per acre developments, and as communities, we're united in opposition to this development. This proposal injects a high-density housing development right inside the heart of our community. After offering this background on me, I'm going to confirm why I think that you are here. I believe that you sit on a citizen commission to help preserve and shape our county's desired vision, advise county commissioners, and hold zoning staff accountable for top quality and ethical work along the way. I expect you to reject this petition if you believe this developer has failed to submit their application with accuracy and honesty. Mattamy Homes has agreed to be held to this high standard as witnessed by their affidavit of completeness and accuracy. I understand that a knowingly false, inaccurate, or incomplete information provided by me will result in denial, revocation, or administrative withdrawal of this application, request, approval, or permit. That's the wording within this affidavit. So my goal today is to highlight the many areas that are false, inaccurate, or incomplete, and I implore you to reject this application. As a fellow Palm Beach resident, I look to you to provide the checks and balances in the development approval process that helps preserve the special place that is Palm Beach County. Your Unified Land Development Code requires the petitioner show that change must occur for a good reason. The document must show this reasoning in their justification statement. It should be the crux of their application, and for that reason I start my objections with this document. Mattamy Homes' justification statement falls short in 3 critical areas. Existing land use. Mattamy claim that it is impractical to reconstruct the clubhouse or to operate a golf course. Simply because the current golf course owner has no appetite for golf doesn't mean that it's not a viable business. Golf course players in boom, and during my research I've come across many golf course operators who have strong interest to buy the land and restore it to a high-end golf course. Mattamy provided no data to support their position, and staff should not accept their inaccurate statements as they've not provided any independent research to validate it. I have submitted to staff numerous articles on the status of the golf market for the record. This golf course land was part of a $1 billion inheritance when the original owner died. This is not owned by a mom-and-pop operator struggling to pay their bills. The owner has intentionally dismantled the assets of this course to give the impression that housing development is the only possible option. They know that a developer will offer them the highest possible financial return. On land use, their justification statement is false and inaccurate. Second is environment. Mattamy failed to provide any environmental data and downplay its importance within this property to simply an offer to mitigate the harm that they will do. I've submitted a detailed analysis of environment aspects to you from certified environmental scientist Mr. Greg Braun. Greg will hopefully be speaking later to expand upon his research. Sherbrooke is a special area with many protected species that would be destroyed by this development. We would have expected them to identify these protected species before permission to proceed is given. On the topic of the environment, their application is grossly incomplete. My third area of concern within the justification statement is residential character. Sherbrooke Estates is low-density, rural residential with every home different in size and style. The developer claims that the increase in residential density is compatible and consistent with the existing character of the surrounding lands. False and misleading. If it was truly in the same character, why do they need buffer zones? Remember, you need just one false, inaccurate, or incomplete statement to reject this application. I've just given you 3 in their justification statement alone. So this site plan is disingenuous to the intent of the rules. By counting land here and there and placing lakes and open spaces far from future housing, Mattamy are effectively clustering housing at levels far above the intended zoning. To relocate existing lakes to make space for their houses, this application considers expanding one lake and creating 6 new ones on section of the golf course that don't touch a single point of their home-developed land. It's all on the other side of existing Sherbrooke housing. Look at some of these distances. That's over half a mile that they've moved some of these lakes. Completely the other side of their development. Sherbrooke is zoned at 2 houses per acre. Mattamy are building at 5.87 houses per acre and expecting credit for the 104 acres of the golf course land that they're using for mitigation of the environmental harm. Sherbrooke is built out at 0.44 units per acre, or 13.3 times less dense than Mattamy are proposing. Is this really consistent? How similar is this development to our existing neighborhood? To illustrate this clustering in a way that I can relate to, I looked at my own home. I own 2 acres of land. This is an aerial view of my home within Sherbrooke Estates. Here's my lot. I view this lot as the very best piece of land in South Florida, and I've lived in 12 different homes in my 22 years of being a Floridian. It's elevated at 28 feet above sea level. I'm surrounded by water on 3 sides, and my main living room looks west, so I get spectacular sunsets every single day. If I make a phone call while standing outside, I'm usually asked if I'm at the zoo, as the background bird song is so loud, and the only thing you can hear. The equivalent of what Mattamy is asking you to approve would be for me to put 11 houses on my lot. I think this destroys the magic. Would you let me build 11 houses on my 2-acre lot? I've included a thin row of trees as a buffer to my neighbors. Trust me, it's compatible with the existing housing style and community and character. I'm telling you so because I'm a developer and you trust me, right? And I forgot to mention, I bought these 2 empty lots, so the average housing density is under 2 per acre. I moved 55 mature trees over here, and I dug a new lake over here. It's all good, right? I'll mitigate any environmental damage honest. I certainly hope that this would not be approved. And on a micro scale, this is exactly what Mattamy are asking you to approve. The developer and staff have been very happy to pick and choose when to include the entire PUD acreage in some calculations, but just the golf course lands in others. The current zoning of Sherbrooke is incorrect, which has led to this opportunity for an unscrupulous developer to game the system. Sherbrooke averages 0.44 homes per acre. Mattamy's idea of compatible and consistent is 5.87 homes per acre. I'm no land use planner, but this simply sounds false for staff to sign off on this as consistent with the Sherbrooke community character. On top of the development order amendment, there's a tandem, if not phantom, application for a community development district. Community Development District is a nice-sounding name which really means a financing tool for developers to cover infrastructure costs over many years, paid by new residents. The tool is used when local government won't take on this development debt. Do you know how they work? Most of us don't, and I'm certainly not going to try and explain it. My research has found that many CDDs have failed, and legislature has been struggling to monitor and manage them with updated regulations frequently developed. What is clear is that there's insufficient and conflicting information within the application, and unless there's been a CDD charter delivered to staff outside of the application process, there's no way that this Commission can move the CDD request forward today. The application is incomplete and insufficient documentation provided, causing complete skepticism and objection. Traffic. I have a very quick comment on the dark art of traffic analysis. I've read every page of this application, and when it comes to traffic pages, it truly is a mystery to me. The analyst put numbers in the county TPS system and relies upon a complete result being kicked out. I commissioned and have submitted to staff a traffic analysis by Lisa Bernstein. Lisa found one error in the Mattamy analysis in that they should have classed Lantana Road as a Class 2 road when it was classed as a 1. Not a significant impact in itself, but this error was not caught by staff. Also, I asked Lisa about the traffic generated by the new high school being built on Lyons Road. She said that it's not adding any traffic to these numbers as the plans show not approved on the county website. That's over 2,000 trips a day that aren't being counted. What other errors are there in the county's online tool that all traffic experts rely upon for accuracy? What's the long-term intent? I challenge the developer to tell us that this application is not just the first step towards more infill, that there are too many not at this time responses in their answers. Trust is of central importance in moving forwards with a decision like this. This application sets out promises that Mattamy is making to the county to be a good contractor and a good neighbor. Mattamy's community outreach has been nothing more than systematic misinformation. Members of the Sherbrooke community and myself have attended these poorly attended community outreach sessions. When questions about specifics, the developer's representative had no answers and failed to know simple geography about our neighborhood. As you've witnessed today, there was a lot of, I'll come back to you, I'll have to look that out. And I'm going to call a little audible on my presentation. When they put up petitions in objection, there were 3 names on the board. 2 of them weren't in our neighborhood. There was one in our neighborhood who happens to be in this room today. Addie, can I call you out? Were you in objection?
Excuse me, please.
Yes.
Can you just revert to there? She can speak after.
Okay.
Yeah, please.
Her name was on the board as in support of Mattamy. She's a member of our HOA board. She didn't sign a petition in support of Mattamy. So the only member of the Sherbrooke neighborhood that they've put on their petitions as saying is in support of Mattamy is false.
Excuse me, please. Can we please stop the applause, the comments, the laughs, the boos, and you continue your presentation?
Very good, Madam Chairman.
You.
Thank you. Mattamy present themselves as offering a new plan for a better future of Sherbrooke. They've painted our community as run down and in need of a savior. Nothing could be further from the truth, and Mattamy is no savior. The Better Business Bureau rates Mattamy an F. The internet has plenty of negative reviews of Mattamy's honesty and integrity. There are literally hundreds of negative reviews about Mattamy online. I've just pulled a few samples for you. Awful company and service, terrible home builder, no one shows up, never buy a Mattamy home, their homes are terrible. While zoning staff have no obligation to provide only A-rated companies, I would hope that at some point someone would consider the moral compass of the developer. Mattamy Homes have lied by omission on their application and lied in their community outreach, as they will continue to lie to future home buyers. This is not a good company. I have highlighted many of the reasons that I don't trust Mattamy Homes, and I don't think that you should either. I would like to thank Amin and Lisa specifically from your staff for their assistance in registering the petitions and technical documents that I've submitted for this presentation. As a non-developer with no experience in these things, this has been a daunting task to stand before you today. I love my neighbors and the community that is Sherbrooke Estates. There are 101 spectacular stories that I could have shared with you about Sherbrooke's history, unique architecture, amazing environment, and the personalities who live here. I'm speaking before you with the proxy of over half the community. I've tried to remove emotion from my presentation and stick to the facts relevant to the permitting application. You don't have to agree with every point I've raised. You just have to agree with one to be obligated to reject this application. I urge you to vote no to this proposal. Please help Palm Beach find a balance between capitalism and individual property rights. Thank you for your consideration.
Excuse me. Okay, excuse me. Excuse me, can we stop with that, please? Or we won't move forward with any other public comment. Thank you. Okay.
Any questions?
Thank you.
Okay.
Any questions from any of the commissioners? Okay,
Actually, no, I do. I have a question because I only see 2 cards here that asked for him to speak on their behalf. So I don't know where that came from. Why we afforded him 15 minutes.
Did we have anybody else that was going? Staff?
Staff has submitted the petitions that the representative here submitted into the log. We have 80 of them, and they're all in the contact log.
Okay. So they were petitions.
Okay.
Comment cards?
I have 2 for him to speak on their behalf. That's what I was asking.
I was in communication with Chairman Kern, I thought was going to be chair of this meeting prior to about a week before, provided the petitions, asked what the requirement was to be allocated extra time. That's the process that I followed, and I was advised by staff that, as you did, you voted on the ability for me to speak, and I'm here and I've spoken.
Okay. I did have a question. Well, actually, I would like staff to speak because you raised a comment, and I think it's, to afford you to speak on the traffic. The statement that you made. I would just like the clarification for the record because that was, I just think that needs to just be addressed and answered. The point that you had made, saying that it was an insufficient class. The class was wrong?
The class was wrong on the road, and also the TPS system has an error on a unit a mile away from our development that's going to generate 10,000 trips a day. It's showing on the TPS system as not approved, so it registers 0 in the system.
Okay, so it's more specific to the class because they do a lot of extensive work, so if you can just speak to that to clarify that point.
Yeah, we received this, traffic report just yesterday morning, and we were all out for the BCC meeting. It went very long, so we didn't have a chance to look at it thoroughly. But one thing we noticed that in the report itself, it says that due to this classification changes, there will be one additional link that need to be analyzed, and that link doesn't fail. It actually meets the TPS standard, so it's not going to make any difference. But we did check the classification of that link this morning for that particular link in question, and the statement in the traffic report, in the developer's traffic report is correct. It's the classification they used in that report is correct. We verified that. So it's not going to make any difference at all in the traffic TPS standards.
Okay, all right, thank you. Okay, any further questions at this point for the gentleman? No? Okay. We do have a number of comment cards, people that wish to speak. Once again, if there is any outburst we will cease the public comments. We just want people to come, make their comments, their opinions heard. 2 minutes is a hard stop.
Will be escorted out.
Okay, yeah, okay. So anybody that does make any kind of noise, ruckus, stands up, applauds, you will be escorted out to afford the people at the podium their 2 minutes time, to speak.
Madam Chair, if just a moment, I am John Jorgensen. I'm the attorney representing the Sherbrooke Homeowners Association. I did put on my comment card that I needed an additional time, like 10 minutes. I'm sure there's at least 10 people who are willing to give up their time for me to speak.
We would need to see those cards before you spoke, please. So until
We
that
need to,
time, can we please get the
We need to
people-
allow the attorney the extra time, so you need to give him 10 minutes to make his presentation.
Thank you, Mr. Banks.
10 minutes.
Okay, hold on one second.
May I proceed? Thank you, Madam Chair. I am John Jorgensen. I represent the Sherbrooke Homeowners Association. I'm going to speak on two topics and two topics only. One is the deed restriction, and the other is the failure of the applicant to meet the standard of changed conditions and circumstances. First, the deed restriction. The deed restriction has been in place since 1976. It's been in full force and effect for 46 years. The deed restriction is an express deed restriction contained in a warranty deed that conveyed the golf course property to the Sherbrooke Golf and Country Club. Again, that was in 1976. The deed restriction provides that the golf course property can only be used as a golf course and country club. The deed restriction also provides that the restriction runs with the land, and further provides that anyone who has property contiguous to the golf course may bring a lawsuit to enforce that deed restriction. There are many people in this audience that have property that is contiguous to the golf course, and in fact, the Homeowners Association itself has property that abuts the golf course. Because of this deed restriction, when we learned that Mattamy Homes was seeking to rezone this property, we filed a lawsuit, I think it was April last year, seeking an injunction to prevent the development of this golf course property with single-family homes and townhomes. There is a case management plan that has been provided by the court and is filed by the court, and we anticipate that we're going to have a trial this summer to get that injunction to prevent development of the golf course. So, for reasons unknown to me, the county staff and legal staff take the position that they will not consider what they refer to as private title matters, but this is an express deed restriction. It will affect anything that this board does regarding a recommendation one way or the other on this application. So this application is premature. The lawsuit ought to make its way through the courts. We ought to wait for the court to make a decision on this deed restriction before going forward with the rezoning. There were some questions about whether or not the homeowners engaged with the Mattamy Homes concerning this application. The reason they did not, by and large, is because of this pending lawsuit. We do not want to give up anything because we think we have a valid deed restriction. And we're not going to engage in discussions on more buffer or whatever, more compatibility this way or that, unless and until the court makes its decision on this deed restriction. Now, I personally think Mattamy Homes is taking advantage of the county by going forward with this rezoning process. So if they get it, and if this board and the Board of County Commissioners ignores the deed restriction, Mattamy Homes can come into court waving that they've got their rezoning, and look, here's another reason why this deed restriction should be thrown out. So, with all due respect for staff, I think they're incorrect in their position. This board has the discretion to consider this deed restriction, and it ought to either deny this application or at the very least postpone it until the court makes its decision on the restriction. The other point I want to talk about is this changed circumstances and conditions. One of the standards that the applicant has to meet is changed conditions or circumstances, which states there are demonstrated changed site conditions or circumstances provided by the applicant's justification statement that necessitate a modification. In its application, Mattamy Homes, as you've heard, talks about the golf course closing down in 2016. I'm going to stop there just for a minute. Max Schwabel was a billionaire philanthropist. He built this golf course because he loved the golf course. He wanted it always to remain a golf course. Therefore, when it was deeded to Sherbrooke Golf and Country Club, that deed restriction was put in there. When Mr. Schwabel passed away, the property went to his heirs there was a special warranty deed that went to 4 LLCs that constitute, his children who took the property in LLCs. That was in 2016. In 2016, the owners decided to shut down the golf course. There's one of the principals of the LLC, David Diamond, made that decision to shut it down. When that was happening, there was a group of homeowners who approached Mr. Diamond. They wanted to buy the golf course. They were prepared to spend several $1 million to buy the golf course to keep it open as a golf course. Mr. Diamond gave him the cold shoulder. He wouldn't negotiate with him. Ultimately, he said, I want $10 million for the golf course. Well, it's not worth $10 million as a golf course. It's worth $10 million or more to a developer, but that is not a changed circumstance or condition which would support this application. So the golf course was shut down. And when you shut down a golf course, it goes to seed very quickly. Now it's just vacant land. It has to be completely redone. That renovation cost is like $4 to $5 million. So that's the situation that was created by the owners themselves. It's similar to coming in and asking for a variance based on a hardship when you've created the hardship yourself. They could have sold that property in 2016, and we would have an operating golf course today. The other thing going on is this resurgence of the golf industry, and this is counter to what the applicant stated in its justification statement. According to the current trends in golf industry, it's impractical to reconstruct the clubhouse or to operate the golf course. And that's their changed circumstance in addition to the 2016 refusal to sell it to another golf course operator. But as Mr. Connor has stated in his testimony, golf has had a resurgence. We need look no further than the article that was in the Palm Beach Post this weekend. Golf, again, is very popular in Palm Beach County. People are going on membership lists to join. Younger people are playing golf. Golf is back. People are moving down from up north, New York, New Jersey, other areas. They want to be outdoors. And golf, indeed, is back, and the golf industry is no longer a dying industry. So that's their basis for their justification statement. And what did staff do? Staff just accepted it. Staff didn't do any due diligence on its own. They accepted this false narrative by the applicant. And part of what staff says, they repeat that the golf course has been closed, that the clubhouse burned down. Then they conclude there are many other golf courses to choose from throughout Southeast Florida, and the competition creates long-term economic sustainability concerns for operators. This is just false. With all due respect, staff did not do any due diligence here. So for that reason, too, the application should be denied. Again, I think this is premature. We have an ongoing lawsuit with this deed restriction. This needs to be decided first, and then the staff needs to go back and do its own investigation, do its own due diligence, and to determine whether this narrative put forward by the applicant is true or false. All indications indicate that the narrative is false and that they haven't met changed circumstances and conditions. So I would respectfully request this board to recommend denial of this application, or at the very least, to postpone it. Let this work its way through the courts. Let's get a judicial decision and see whether it makes sense to have this rezoning at all. Thank you very much. And I'd be happy to answer any questions.
Any of the questions for commissioners? No?
None.
No. Okay.
Thank you.
Thank you. We'll resume the public. Sherry?
Okay, we have 14 cards, which unfortunately were submitted after we began, so they do get entered into the record. However, you do not get to speak. We also had 39 cards submitted that did not wish to speak, that were opposed, and we had 2 cards that were submitted that were in support, and they did not wish to speak. I will now begin with the cards where they did not wish to speak, but would like their comments read into the record. So I will start with Lone Vo, and I apologize in advance if I do not pronounce your name correctly. Opposed. Building a lot of homes within acres, a lot of homes does not add value to the area. Renee and Delphine Benninger. We strongly oppose the development. Palm Beach County is getting overdeveloped. Please do not make this another Broward County. You live here too. Did not wish to speak. Stephen Mecca. I am 100% in favor of Matamy's development of the Sherbrooke Golf and Tennis. There are a few issues I would like to amend on the site plan. This needs to be approved by the county, and the dream of revitalizing the golf course is ridiculous. Joan Wolf. The project will affect me in a negative way, so I have will not affect me in a negative way, so I have no objections to it as long as it is in keeping with the surrounding communities. Alan Capps, I believe approving this community would enhance the community to give the needed improvements to land values and help Palm Beach County in achieving a newer community for potential new homeowners to live. Alan Hammer. We are in full support of the project by Matamy Homes. This will improve the area. Anissa Cruz. This project will help improve the surrounding neighborhood and provides numerous benefits to the community. Carolyn DeSanti. I fully support Matamy's plan for Sherbrooke. I think that this plan will improve the land values in and around the community. Daniel Goldberg. I am in favor of Matamy's Sherbrooke community. Palm Beach County has many shuttered golf courses that are providing no benefit to the county or community. I have seen Matamy's other projects, and they add value. They're well-designed and well-built communities. I believe Sherbrooke will add value with new residents, well-built homes, and a generous amount of green space. David Botnecht. We strongly support this community in an effort to provide much-needed housing in the area. This will serve as a benefit for the entire surrounding area. Debbie Siegel. I expect the soil will be remediated for health and safety concern when children and adults will live after the use of golf course contamination. There has never been a study of school-age children potentially attending the local schools. Woodlands Middle School, Discovery Key Elementary, and the new high school to be completed in 2023. What plans does the community have for public access and safety to parks? Gordon Mintzner. Increasing the tax base in existing areas of Palm Beach County only helps to lower budget issues. Jackie DiNatale. Matamy's project in Sherbrooke would be a great addition and will add value and growth to the area. James Boatwright. This would be development would be an asset to the community. Joseph Ansaroff. This project by Matamy Homes can increase nearby property and land value as well as create local jobs in surrounding areas. Julie Hurst. Julie, I support agenda item C9. Megan Blotnick. The new homes and amenities in Sherbrooke will help grow the neighboring areas. Sherbrooke will help to improve land values in Palm Beach County. Michael Gertman. My daughter and her husband purchased one of the original few homes at the Enclave at Boynton Waters. The rest of the development besides these few homes remained barren for many years. Matamy came in and completed the development with beautiful homes of similar size, completely selling out and beautifying the area. Their home is now valued well over $1 million, a tremendous increase that would not have been possible had Matamy not completed the development that had been left stagnant by the previous builder. Neil Hassett. This community would bring more business and revenue to the city and its vendors. Robert Barbuto. Matamy Homes is a reputable builder and will bring beautiful improvement to the old golf course. I am in full support of this project. Robert Walsh. I fully support Matamy's project at the Sherbrooke Golf and Country Club. The current project as situated is an eyesore and detrimental to local property values. The project as constituted will help improve our neighborhood and provides numerous benefits to the community, including the developed open space, enhanced views, and increased value. I have not met with Mattamy, and I am not affiliated. I am just a concerned neighbor to this potential development. I have viewed other projects by Mattamy when entertaining prior home purchasing, and they have developed beautiful spaces and enhanced the communities they are part of. The property is already zoned residential to allow this type of development. There is a competitive market for similar homes in the nearby area, and this will have a positive impact on property values and the greater nearby community. Thank you for your consideration, and I invite you to call to discuss if you would like more feedback. Ronald Mardon. My wife and I are in support of Mattamy Sherbrooke development, as I believe it would bring value to the neighborhood and will also help with crime and to preserve the area. Sherry Del Grosso. I support the new community at Sherbrooke. Sylvia Hammer. We are in full support of the project by Mattamy Homes. This will improve the area. Toby Shapiro. I am in total support of this development to be constructed. It is not large. There is more than enough open space. This will be an asset to an area that is currently not being utilized and is a place where unacceptable behaviors can and have occurred. Thank you. William Price. I very much support the community proposed, Sherbrooke. I invite the idea of having another community buy my home to bring more businesses and to see my home go up in value. Please allow this to be started. Those are the, sorry.
Excuse me, through the chair. I just want to point out that we're no longer collecting online comment cards. Everything that you're reading on a piece of paper was not filled out in this room. So I highly question if anyone on those pieces of paper are in this room. I apologize that we gave them to you. In the future, we're not collecting or distributing pre-printed cards from home because we have no record of these people actually being in the room, and I very much apologize for that.
Okay. All right. Do we need to make any motion then about these that she just read?
Any of the paper ones, if anyone in this room would like to stand up that they filled out one of those paper things in this room, I'd like to see them.
Okay. Not the cards, anything that she just read.
In an 11 by 17 and your name was just read and you gave an 11 by 17 paper?
Okay, okay.
Yeah, we're not collecting online cards anymore. The online cards were done for a period of time when we were doing WebEx comments for the people to be at home, so I apologize.
Okay.
Madam Chair, I'd move to strike the
Excuse me, the commissioner is speaking. Thank you.
I'd like to move to strike the subject comment sheets from the minutes.
Second.
There's a lady over here, I believe, that did.
I sent in a certified form that was not read.
Okay, no. We're just speaking specifically to the cards that were just read.
Okay.
And if your name was not one of those, then it doesn't apply to you.
Okay, when will my certified letter get read?
If it was a certified, it would be submitted into record. Anything certified like that would be submitted into record. She's just referring to cards that were received letters, the people there that we can't account for being in the room. Okay? So your card has already been submitted into record. Okay?
Would that be read out?
No, not if it was submitted into record. There's a process for that. Okay, that you indicate that you would like it to be read out, and there are people that are here that submitted cards but do not wish to speak that would like their comments read into record. So yours would just be submitted and is part of public record and would be acknowledged, but it won't be read out.
Do you recall if the form had an option to be read out?
Okay, ma'am, if you want to speak today, you would have needed to fill out the card right here at the entrance.
I'm the first person she read.
Okay.
It wasn't as long as what I sent in the
Okay, so she read your card.
That's what she just asked.
I did read hers.
Just a card, I sent a certified letter.
Okay, well, we have a motion. Can
We need to move
with
on.
our motion?
Okay, all right, we just have two
Motion and a
separate
second.
things. Yeah, we have a motion on the table to strike the cards, the letters that were read for the people that are not present.
If they've already been, they're already part of the record, so you really can't strike them. They're part of the record of the proceeding.
I feel like my voice
Okay, just one moment, please. We're just addressing the initial situation, and I'll come back to you. Okay, thank you.
For the record, we can comment on, or if she'd like to come to the mic, state her name, we could write on that card she was present, but all of the other ones we're going to account for as not being present in the room.
She's not in one of those cards.
Oh, then she could fill out a little
She
card
said that
doc.
she filled out a card.
Okay.
It's just, she also sent a letter certified, and she does not feel that what was read into the record from her card covered what her letter did. Obviously, her letter's much longer than what her card is.
We don't, for the record, we do not read letters received at the hearing. The purpose of the public hearing is for the public to speak. We have a stack of letters on all petitions, and we publish and we record as part of the record in our comment log. Her comment, as you stated, is part of that record.
Thank you.
Let's move on.
Okay, I'll pull the motion if there's no reason, if it's already in the records and we can't strike that
means I
in
get to
minutes,
pull
then
my
I'll pull the motion.
My second's gone.
Okay.
Okay, so now we will go back to the public. For those that do wish to speak, when I call your name, please come up to the podium, state your name and your address. Deanna Hall, I apologize. And then after Deanna, it will be Gunnar Mansons. Gunnar, if you want to come up to this podium. Thank you.
Thank you. Good morning. My name is Deanna Hall. I am a current resident of Sherbrooks Estate. I reside at 6715 South Calumet Circle. I would like for the record to reflect I'm also the CEO of the Broward Palm Beaches and St. Lucie Realtors. I am not here in that official capacity, though I do know something about property values as building the third largest realtor association in the country. So a year and a half ago, I was able to reach my lifelong dream in this very special community called Sherbrooks Estate. My home is actually next to the home that my grandfather built over 30 years ago. And when he passed away last month, I was humbled to think that his piece of the American dream was still living right next to me. This community is special because it has gone to great lengths to preserve the Florida that many of us all fell in love with. There is still that unique Florida wildlife in our neighborhood, and the community is not gated, which reminds me how our neighborhoods used to be in Palm Beach County. We are eclectic, diverse, and we truly appreciate what we have. You cannot tell me that approving this development will not negatively impact our neighborhood. You cannot tell me that this Mattamy development is consistent with our neighborhood. The Mattamy development is a development that is next to ours. It's not just next to ours, it is literally inside of our neighborhood. I mean, the properties are woven throughout our properties. There is a big difference and a much higher threshold that must be met to be considered when you are calling this neighborhood compatible to ours. So this is just more of us wanting you to be heard throughout this entire hearing process. So let's talk density and appropriate zoning. Commissioners, Mattamy is building at about 30% of the golf course land at a very high land use density. That's 0.17 acres per home unit. Then claiming credit for green spaces and lakes on land that is not contiguous to their development. If you follow that theory, I would be able to build 5.75 homes on just 1 acre of property. You have to take a moment and really envision what you're approving and approve it fairly throughout this area. The improper zoning may give them a right, but it does not mean that they can cluster all homes
I need you to
onto a
wrap
small
up
piece
shortly,
of land.
please. Thank you.
Excuse me? We're
I
done?
need you to wrap, yeah.
Okay. Oh, I thought I had 3 minutes.
No, 2 minutes.
Okay. Thank you for your time, and I hope you consider all the facts here today.
Thank you.
I have a document I'd like on the screen.
Okay.
How can we do that?
Does Steph want to take his document? We'll enter it into the record.
I'd like it on the screen so everybody can see what I'm talking about.
No, that we can't do. I don't.
You can, no, you can pass it. If it's something, we can receive it, and we can, the commissioners can take a look, and then we can submit it.
Well, actually, this came in the packet that I picked up at the door here.
Okay.
I originally brought a map to illustrate what the issue is, but they did a better job bringing it themselves. If everyone looks in their package for the document.
Okay, excuse me, we're going to start the time if it's something that you would, and we can submit that, okay?
I believe that was already submitted.
It was already submitted?
Yeah,
Okay.
submitted.
All right, we're going to begin the
Can I
time?
start?
The last
Yes.
piece of
Okay.
the add delete.
Gunnar Manson, 6640 East Calumet, of Sherbrooke. Recently, I came up with an issue that was hidden in plain sight by Mattamy Homes. What they have done is they've decided to take a certain part of the land, the part that they're calling open green space, and they're going to turn it into what's called a CDD, Community Development District. This is land that has to be supported and paid for and maintained by the new homeowners, who have no interest whatsoever in maintaining this land. They are advertising 68% open spaces, which is a land dump. What they're doing is they're using land that's not contiguous to their new neighborhood, that's going to be left unattended, unsecured, and why would anybody in a new neighborhood spend money to keep up land? Now, all of this land borders all of the other communities and us, but yet we have no control over this land. It is a land dump. CDDs were not designed to throw land away that you can't use, and some of this land is only 20 feet wide, golf cart trails going behind people's homes. I also want to apologize to the board for the outburst of the community here when the subject came up about people living in the community, vagrants. The reason the laugh came was because there's a picture being circulated on behalf of Mattamy of 2 tents where homeless people are living. The problem was these 2 new tents were brand new, very expensive, and whoever erected them left the boxes that they came in, and that was a farce because nobody ever moved in. And if homeless people could afford a couple of $100s for tents, they wouldn't be living in homeless tents. So that's why the laughter came, and I apologize. It's something you didn't know that we knew.
Okay. All right.
But I ask you to reconsider this because nobody in this room knew about the CDDs. It has just come up, and a CDD was never intended to use as a land dump, and that's what this company is doing. Please look into it. It's Statute 190. I read it, and it was not designed to get rid of land. Now, affordable housing is going to be built.
You're over the 2 minutes, sir. You're able to wrap up, please?
Yeah.
Thank you.
Affordable housing will not be affordable when these people have to pay to maintain land they can't see or use. It's a real problem. Thank you.
Thank you.
Thank you. Next, we'll hear from Jane LaSalle, if you want to come up to the podium, and then at the other podium, Katie Reed.
Hi, my name is Jane LaSalle, 6640 East Calumet Circle in Sherbrooke Estates. I'm going to concede my time to Andy Korig, but first I want to make a statement. My door was never knocked on.
Excuse me, if you're conceding your time, then you're conceding your time. You be
The
finished.
entire time I can have 10 seconds?
No, okay.
All right, Andy?
Thank you.
Thank you.
Katie Reed?
Oh, I thought she was conceding her time to that gentleman.
Yes.
Okay.
Hi, my name is Andy Korik. I'm a resident of Sherbrooke Estates since '97. I've served 37 years in law enforcement. I'm a retired police captain and a past president of the HOA. My address is 6989 North Calumet Circle. I'd like to start by saying the county should and must use the considerable power of zoning and project approval to shape land use patterns in a manner that will cultivate a safe, vibrant neighborhood, preserving a variety of lifestyle choices. You should not be removing recreational elements such as a golf course, causing undue congestion on already dangerous roads, increased noise, loss of privacy, and increased crime. Criminologists emphasize that mixed land use and high residential density generate more contact between potential offenders and potential victims. The routines activity theory of Cohn and Felsen argues that direct contact predatory crime requires the convergence in space and time of likely offenders, suitable targets, and the absence of capable guardians. This indicates that Sherbrooke will become prime targets for theft, burglary, then when you introduce high-density housing and public access directly in the center of our community. Mattamy plans to designate the vast majority of the property as public areas that will grant legal access to the back of single-family residential homes with no plan on how to stop the inevitable increase in crime. Why would anybody want to use these areas with no infrastructure? They're not even contiguous to the high-density housing areas proposed. Will they eventually plan activities that will invade our privacy further, cause a nuisance? Will they need to lease the areas for public and private use to generate revenue as allowed by statute? Land use of this type brings all new levels of violent crimes to our now peaceful neighborhood. The Sherbrooke Estates community is relatively unknown and enjoys an extremely low crime rate. The project will change everything, including the addition, from what I understand, of a public transportation bus stop, which is not needed now. Our community was built on the promise that the golf course property would only be used for that purpose. Our planned unit development was structured with a golf course as a recreational component of the community. We were never intended to be gated or have walls surrounding us to protect us from a golf course, and we cannot do these things now due to land restrictions.
Thank you for your comments.
And original design. That's it?
2 minutes.
Are you cutting me off?
No, I'm sorry. Go ahead. We'll give you, I guess you're taking your time, but after you're done speaking, since we don't, did you fill out a card?
I did fill out a card.
Okay.
Yes. Okay.
You
cannot ignore the legal promises that shaped the design of Shorebrook PUD and will now leave the residents of Shorebrook vulnerable to increased crime, congestion, noise pollution, and overall destruction of the PUD. I have seen many neighborhoods deteriorate due to multiple families living in very small houses and townhouses to reduce costs. How will Mattamy prevent this from happening? I suggest that Mattamy will be fostering economic hardship on their residents by adding additional taxes to support their land dump proposed as community development districts. Mattamy Homes has proven to be disingenuous, producing and distributing a very elaborate notice titled the Sherbrooke Golf and Country Club, a new plan for a better future. Nothing could be further from the truth. The entire notice is created on embellishments, propaganda, and lies. The wave of the future need not be high-density housing. Studies have implied that housing and land use policy stressing low density should be reconsidered before it's too late. I stand before you in strong opposition to the Mattamy project and ask that you do not assist in breaking promises that legal documents provide. I ask that you deny this application as we litigate to ensure this land can only be used as a golf course and country club. And just as a side note, I can tell you that we've been approached by people that want to buy the golf course, but they can't get an audience with David Diamond. Thank you for your time.
Thank you. Can I have your name?
Andrew Corrick.
Andrew, I do not see a card. Would you mind filling another one out for me, please? Thank you. Thank you. Katie Reed?
Yes, good morning. My name is Kathleen Reed, and I'm a resident of 8900 Club Estates Way, the community of San Messina. I've been a resident of this property since it was built in 2005. I'm here with you today as a very concerned homeowner as well as a 24-year real estate professional. I'm a licensed realtor, broker associate with Realty Group, United Realty Group. My neighbors and I are in a community called San Messina, and we are extremely disturbed at the new housing proposal by this builder. We had purchased our home with the complete knowledge that there are restricted deeds and titles regarding the land at Sherbrooke. We would never have paid a $50 lot fee in order to have our home overlook the 17th and 18th greens as well as a big, large, beautiful lake. The presidents that are here, Steve and Jay, will attest that we were never once contacted by the builder for a virtual Zoom meeting to attend any HOA meetings or anything. I'm on several committees with San Messina, so I would have been absolutely contacted. We were never knocked door to door. We were never contacted other than the flyer that came in the mail. That was a complete, total marketing disaster. The rep had no answers for any of the questions that the board had sent to them regarding the vagrants, any of the sheriffs getting called, or any of that. They had nothing to back up. As far as the transportation goes, in the last 10 years, as of last month, there have been 5 fatalities between Lantana Road and Hypoluxo Road in that corridor. So traffic is a major concern with this new development. Also, the entrance and exit that they are proposing are basically at the bottom of the bridge that goes over where there's that underneath walkway that they want to make a pedestrian walkway. So we've had 5 fatalities in 10 years in that stretch of land. So that is definitely a concern. As far as the schooling issue goes, I don't know what.
Thank you. Your time's up.
Why did we go from 3 minutes to 2 minutes? I feel like because people that asked for extra time has now been taken away from the citizens.
No, that's not true. We
You
don't
said
have
3 minutes at the beginning.
I said 2 minutes at the beginning.
No, you said 3.
I said 2 minutes,
2 minutes.
at the beginning, and that's
William
public record.
Bernstein. And then Leslie Goldblum. Goldblorn.
My name is Bill Bernstein, and I live at 8779 South Kendale Circle. New developments have to be compatible with existing neighborhoods and is defined by the zoning code as land uses that are congruous, similar, and in harmony with one another. The Mattamy development is a textbook example of non-compatibility. I live on 2.5 acres, as do most of my neighbors. I have a lake, which I own fee simple, and have the ability to have up to 2 horses. I have 300 feet frontage on the golf course, as do my immediate neighbors. We see over 1,000 feet in every direction with few houses. I see no houses from my backyard facing the golf course. My house occupies 2.5% of my lot. These large lots with our expansive views is what makes us unique. Mattamy proposes a density of 15 times ours. Mattamy proposes lot coverage 20 times mine. We have quiet streets with few houses, although the houses are up to 10,000 square feet, frequently have tennis courts or pools or horses. We have very little traffic and noise. Mattamy, with its high density, large population, clubhouse with pool, is the exact opposite. Zoning staff initially found no compatibility. We agree with them. But staff then went on saying there was compatibility because of buffers, open space, and lakes, which mitigated the negative effects of Mattamy. Staff appears to have rewritten the code to exclude the need for compatibility. The proposed so-called mitigation actually does no such thing. Mattamy's development is so radically different and would have such an intense and powerful negative impact on Sherbrooke that no amount of typical mitigation would work. Buffers.
Thank you for your comments, sir.
Okay.
Leslie?
Thank you for hearing me. I'm Leslie Gold. I live at 6919 North Calumet Circle, and I have 2 points to make. When my husband and I purchased our home in 2019, we asked about the status of the golf course and were told about the deed restriction. The deed restriction was so pivotal to our decision that we had it researched and reviewed by an attorney who told us then that it was enforceable, that it contained some of the most restrictive language he had seen in any deed restriction, and that it ran with the land. The idea that this body would approve a development that would trample over written and recorded rights of individual homeowners, I think would be shameful. Does this body really want to be approving something that ultimately would be deemed illegal? I would think at minimum the prudent action would be to table any zoning decision until after the legal decisions have been settled. My second point is this. If your staff has a responsibility to ensure development is compatible with existing neighborhoods, with respect, they have utterly failed. Sherbrooke Estates is not a community that was built by a single developer who put up cookie-cutter homes. Every home in this neighborhood was custom-built by its owner over the course of 40 years. My modern home was built in 1983. My neighbor's mission-style home was put up in 2002. My other neighbor just put up a Spanish Mediterranean, the first build on that property, in 2021. No 2 homes are the same, and they are all situated on expansive 1, 2, and 3 acre plots. This is not a developer's neighborhood. The idea that identical townhouses with shared walls and 0 lot lines is compatible with this is absurd. I point out that this proposed development is not merely adjacent to our community, it is thrust into the middle of it on both sides of Lyons Road, and I would think that the notion of compatibility would be even more important in that circumstance. This could not be any more incompatible with our community. So I urge you to vote it down. Thank you.
Thank you. Grant Morwatt, and then Greg Braun.
Good morning, Madam Chair and staff, and to my fellow neighbors. My name is Durant Mowat. I live at 9440 Dundee Drive. I've served in the military for almost 10 years. I currently serve within Palm Beach County as a firefighter for the last 16 years. And when I serve the public and come home, this is my place of peace. This is my dream home, but it's my place of calm and place of peace. Prior to moving to Sherbrooke, my wife and I would drive around and would admire the homes, the open spaces, and dream of our son playing in a nice, safe neighborhood. Now we have it. Sherbrooke is a very different community than its surrounding neighbors. I love the community because of the homes and the open spaces. I fear that this development is going to change that, change the character of our community forever. I ask that you vote no on this decision of development. As you see us here today, we're all bonded. That's a special term. We're bonded. I can't say the same for Mattamy. We are bonded. I ask that you vote no, and thank you.
Thank you. Sir?
Greg Braun, and I believe someone passed up a paper allowing me there a couple of minutes so that I would have 3 minutes. I'm a professional ecologist.
I do not.
Would you speak your name, please? Pamela Murphy. Murphy?
I do not have that card.
As a professional ecologist, I would ask that you give me the professional courtesy of having the 3 minutes that was afforded at the beginning of the comment periods.
Okay, once again, it is public record that I never stated 3 minutes. It was 2. Okay? So if you can go ahead and speak, please, or you're going to run into your allotted time. Thank you.
My name is Greg Braun. I reside at 10370 Trailwood Circle in Palm Beach County. I've been a property owner and lived there for over 25 years. I'm a professional ecologist, a certified environmental professional, certified by the county as a small business enterprise. I've done a lot of endangered species work, not just here in Palm Beach County, but the Treasure Coast, southeastern U.S., Caribbean islands. And during this time, I've also done a lot of work for the county. I've served as expert witness on behalf of the county's legal office. But I'm here today as an ecologist who's familiar with the Sherbrooke area. I've been on the property, I'm knowledgeable about the area, and I have seen a variety of threatened and endangered species on the property. And I believe you were provided a copy of my report a little while ago that identifies a variety of species that were not identified in the applicant's information. I'm saddened that more time has apparently been spent on the contents of the landscaping in the road medians than ensuring the sustainability of populations of threatened and endangered species, several of which have fairly limited distributions. Ensuring the sustainability of populations of these species, wood storks, roseate spoonbills, a variety of things, is of interest to the residents of Sherbrooke. And I ask that before you move forward with this, that you require that baseline surveys for these threatened and endangered species be performed. Certainly that needs to be done before a rezoning is approved that would forever change those open spaces to more roads, rooftops, and developed areas. Thank you for your consideration.
Thank you. Brady Walker, and after Brady, then it'll be Janet Duncan.
Hey, good morning. Brady Walker, 8759 Club Estates Way. That's in San Messina, just north of the proposed townhomes. I'm actually a fairly new resident there. We just moved in last summer in June. And, you know, as my wife and family and I were looking for a home, we were looking for something to get away from, you know, the zero lot line communities and the townhome communities that we were used to farther east. And we found this part of the county to be, you know, really what we wanted, you know, for the future and for our kids to grow up. San Messina is not a zero lot line community, and as I'm sure you've heard from all the neighbors in Sherbrooke Estates, that is definitely not a zero lot line community. We don't think that this is compatible. And specifically for San Messina, we're seeing those townhomes pushed up against our community, right? And there's not an additional compatibility buffer or incompatibility buffer on those plans. If you are proposing to allow them to put townhomes, those townhomes should be buffered within their development, surrounded by single-family homes rather than pushed up to the end next to our community. I also want to second what Katie said earlier about the fatalities on Lyons Road. This section, people routinely drive more than 60 miles an hour. On December 12th, my wife and kids were driving south and saw a motorcycle accident. They were there before the first responders was there, and there was a man lying lifeless on the ground, right? My wife and my kids. They're proposing to put an entrance without a traffic signal because of the geometry of that road and that it's at the base of that pedestrian bridge, the visibility is limited, and I worry that without a traffic signal there will be more incidents like that. So we request that you reconsider this. You know, we don't think the townhomes are appropriate. We don't think zero lot lines are appropriate. And we would certainly, at a bare minimum, need a traffic light along that road. Thank you.
Thank you. Good morning.
Good morning, everybody. Good morning, Sherbrooke and other neighbors. 23 years ago, I was a health and phys ed and special ed teacher in Philadelphia. Came down here to visit.
Please state your name and address.
I'm sorry. I'm Janet Duncan. I live at 6828 West Calumet Circle. I came down here to visit my parents and went to a New Year's Eve party at Sherbrooke. And I said, I've died and gone to heaven. I went back to Philly, packed up everything I had, and my horses, and my Special Olympics riding program, because Sherbrooke is a horse-friendly community. We are equestrian owners that live there. I implemented my Special Olympics therapeutic riding program for kids and adults that are on the autism spectrum, as well as people that needed physical therapy for maybe cerebral palsy, maybe an accident, maybe surgery. My horses are specially trained to provide a therapeutic activity for the riders. I also ride for pleasure myself. I'm what we call in the cowboy world a weekend warrior. I do not compete in Wellington. I ride for pleasure. Through the neighborhood, my neighbors have welcomed my kids riding in my program as well as myself. And I want you to please, please consider the fact that people like me that own horses for riding for pleasure will have to compete with the additional negativisms that will incur should Mattamy build. And I would appreciate it if you would consider that. Thank you.
Next, Mark Waka, and then Scott Van Eck. Good morning. If you'll state your name and address.
Good morning. My name is Mark Kuoka. I live at 9265 Dundee Drive. That's in the heart of the proposed development by Mattamy. My wife, Eva, and I have been homeowners and residents in the Sherbrooke community for the past 3 years. We absolutely love this community. There are very few of these type of communities left in Palm Beach County anymore. We're very appalled by Mattamy Homes that has been misinforming all of us that golf courses are not viable businesses in the current economic environment, that many are closing because of decreasing demand for golf. This may have been somewhat true a decade ago, or certainly before the pandemic started. I have been an avid golfer for close to 25 years. I've organized many international golf tournaments in South Florida for the past 15 years. I have extensive experience in golf, and I know for a fact that golf courses that are well-maintained, well-managed, that have beautiful landscaping, and have well-maintained facilities do not experience financial problems. They're very profitable, to say the least. COVID-19, as best as it has been for most of us, created a huge demand for golf, one that I haven't seen for many years as a golf player and an organizer. In the last 2 years, it has been extremely difficult to book a tee time on any of the golf courses in this area, especially in the morning hours before noon. You need to book a tee times way in advance to guarantee some kind of a decent starting times. Weekends are completely sold out until very late in the afternoon hours. I have information from one of the homeowners of Sherbrooke who works at a nearby public golf course that it brings in an average of $11,000 to $12,000 in daily revenues. This is close to about $4 million a year, which is a lot of money for a public golf course. I also got confirmation of similar financial prosperity at the Atlantic National Golf Course, which is a semi-private course charging much higher rates. They're very profitable.
Your comments, sir.
So I would just ask you to please vote no to this development, and I hope this is going to be true after this is all completed. Thank you.
Thank you. Scott?
Hello, my name is Scott Vanacek. I live at 9215 Perth Road in Sherbrooke. I wasn't planning on coming up here to speak because of our board or the members from the other gentleman that had spoke earlier, but I felt it was important that you heard from somebody in the community. I'm a small business owner. I worked really hard over the years to try to afford something more for my family. And Sherbrooke was that community that really lent it for us. Moving into that community, I work 70 hours a week just to pay the mortgage and the higher taxes that we pay to the county to afford to live there. And there's so many communities in our surrounding neighborhood that are zero lot line homes. And then what do we need more zero lot line homes for? There's been mention to work first community housing. My son's a firefighter, signed in two weeks ago to Palm Beach County. And I am concerned about what he can afford. But I know there's community after community after community around in Palm Beach County that he can go to, that he can afford and work his way up to. We have something in that community that's pristine, and it should be looked at. And if anybody on this committee or committee in the county really concerns about their position, go out and take a look at what we have there. It's something that's unique that you don't find in other parts of the Palm Beach County. Putting in zero lot line homes is just going to add more traffic and chaos to Lyons Road. One thing I want to say before I get off, when I pull out of Perth Road, you can only go south. You have to make a U-turn to go back north. And in the past few months, or I should say in the past 6 months, I've noticed from all the congestion and the new work that's going on south of Boynton Beach Boulevard and north of Lantana Road, the congestion has gotten tremendous, and it's going to be hard to make a U-turn and go back without waiting on a long line for all the traffic going northbound.
Thank you.
Thanks for the time.
And last, Brian Berman. No Brian Berman? Okay. That's it.
Okay, that concludes the public comments. Did you fill out a card?
My husband filled out the card, but however, my name was mentioned by the applicant saying that I agree, and I've never spoken to anyone. Well, no one ever knocked at my door. I never met with anyone in person via email, and I want that off the list.
Okay. Okay, all right, thank you. Excuse me? Okay, did you fill out a card? You didn't fill out a card, though. You're just rebutting what the gentleman said. Is that what you're saying?
What gentleman? No. Because at the time, he mentioned
Okay,
that
just.
my name was disclosed.
She yielded her time.
Yeah, I'm not. Did you yield your time to the gentleman that spoke?
I didn't give any time to anyone, no.
She has no card.
Excuse me,
But you
through the
have no
chair,
card.
when the applicant made the presentation, he put on the screen, petition signed, and this woman stated that her name was used and she didn't sign the petition. So that's
No,
what that's about.
That's not what I stated.
Okay.
I stated the applicant used my name. They had names of 3 owners that gave him approval, and that was agreeing with them, and my name was typed.
That's what she. That's what she said. That's what she just said.
I didn't. You mean by petition, meaning I give petition to Whooper to speak on my behalf?
No. She was just confirming. That's what she just said. That's what she stated. Okay. All right. Thank you. Did you need to fill out a comment card?
Is that what you need me to do so it could go on record that I never spoke to the builder, nor
Yes.
did I give my name?
It's already on record.
By whom?
Go ahead and fill out the card and we'll take it.
Just fill out the comment. If you can just fill out the comment card, okay, stating that it is official record because we're live. But if you fill out a card rebutting that, and that's okay, that will
I
suffice.
just wanted, because you said I could speak at the end and I wasn't.
Okay, no, she clarified, and we do have that clarification, so if you can just fill out the card. Thank you. Okay, I'm opening up to my fellow commissioners. Questions, comments?
Thank you, Madam Chair. In listening to the totality of the presentations, I have grave concerns that the petitioner hasn't met his burden based upon testimony. And that's my comment.
Could you repeat that, please? I couldn't hear you.
Can you hear me now? I'll use my Marine Corps voice. How about that? My comment was that based on the totality of the testimony given, I don't believe the petitioner's met his burden. That was my comment.
Excuse me, can we hold the applause, please? Thank you. Commissioner Pavlik?
I have no comments at this time.
I actually can. I have a comment or a question that a gentleman brought up that there's a CDD being formed.
I would like to address that. There are several items, but that item was an item in the standard question. So yes, we do have a petition in for a community development district. And for those of you who aren't aware of what a community development district, I'm going to spend 30 seconds talking about it, and then I'm going to tell you what we're going to use it for. A CDD is a quasi-judicial form of government. It's allowed under Statute 190. There are CDDs all over Palm Beach County. The intent of those CDDs, typically a developer uses them for financing, operation, and maintenance. This developer is proposing a CDD specifically because we have all those large open spaces, and CDDs, being quasi-judicial in nature, have the ability to do non-ad valorem taxes. So the operation and maintenance of those preserve areas would be placed in the CDD, so there is a dedicated funding source instead of through a property owners association. That's the reason why we're proposing a community development district. And it is also, CDDs are professionally managed. You have a CDD engineer, you have a district service that runs it. So the idea and the reason why we're requesting a CDD, which has not been approved, it goes to the Board of County Commissioners separate and aside from this process, but that is the reason why we're requesting community development district.
Is there a reason why that wasn't part of your initial presentation?
Yes, ma'am, because it's not part of this application, so I didn't want to merge everything together.
No,
So
the
it's-
only reason why I state that is because there is such a large, opposition to it. It would have been prudent to be transparent in the presentation, so that, just to be transparent.
Right, and the CDD then would just be the responsibility of the homeowners of the new homes
Correct.
and the affordable housing, the 10 homes that are affordable housing.
Those,
They have to pay for that maintenance for life.
I understand. I understand a CDD. Believe me. So it's the 10 affordable housing and the other homes in the proposed.
It's the in totality the development being proposed, the 282 units.
It's all the units, correct?
So,
I think,
but I guess what it is, the homeowners eventually pay for the infrastructure, and
operation and maintenance, correct.
Of the entire community.
Of the 152 acres.
Okay, so and then we have affordable housing. That we're putting in.
I think I know where your question
Yeah,
is headed. I'm trying to get the answer.
I've managed CDDs, and I know, it's always quite a surprise what their bill is at the end of the year. That how are they going to afford it if they're in affordable housing, and is that, why would it not, to me, it's just mad at me getting a loan to build the community, and then the community shouldering the loan.
At this point.
Please stop, please.
Yeah. At this point, we're not proposing. And I want to confer with Madame real quick. Proposing. Let me respond.
They are proposing a CDD.
Are you floating debt, Tony? Are you going to float municipal bonds or not? Do you know? I can answer it. Let me get the gentleman up here. The purpose of it is for operation and maintenance. But I'm going to ask Mr. Palumbo to respond to your question, which is, are they doing debt service? Proposing debt service.
I don't know yet. We're just in for it. But I will waive that the workforce housing, not affordable housing, that they won't have any burden.
Thank you. So Mr. Palumbo has opined that the workforce housing, it is workforce housing, will not be party to any of that cost.
That's impossible. That's untrue.
Yeah, sir, who's ever, trust me, I understand these. I understand these. Okay, I get the CDD, okay? My next question is, how wide is Lyons Road there?
I'm going to ask someone to get the
Is it 2
exact
lanes,
number.
4 lanes?
I'm going to get someone to get me the exact answer.
Or staff knows.
Right.
Why am I looking at you?
Good morning. It's 4 lanes within the section within a 110-foot ultimate right-of-way.
Okay, that's all I've got.
Any other commissioners? Comments?
I had a follow-up question. With regard to the deed restrictions, I know that this is not part of, and you said it's separate, but if I could go back to our attorney, it seems like there's a lot of conversation about it. So with regard to, if this were to get approval today, and then it were not to, we talked about this earlier, not to get passed, what does that do to the project?
Right. It's fine. I mean, if it gets approved now and then they lose the lawsuit, it's fine.
I think I already answered that question. If the Board of County Commissioners approves this project and ultimately the deed restriction is found to be valid, they would have to deal with they'd have to then change the zoning to something they could use the property for, because essentially they'd have zoning they couldn't build on. Right.
Okay. But I just wanted to revisit that. I know you answered it earlier, but I just wanted to revisit it after all the comments. Thank you.
I just have, I'm sorry, I didn't mean to interrupt you. You finished? Okay. I've sat through a lot of these and been involved in a lot of golf course controversial developments. But this one, to me, has no business coming to our committee until they've resolved their legal issues. I mean, I understand what the legality of it is. I understand what Bob's saying. I understand what staff's doing all the right things. There's no question. It's just that morally, they're not far from a conclusion with this thing. You're talking about April. I believe that I understand there's a hearing date or something in April, is that correct? No, somebody said there was a...
This summer.
Sometime this summer,
yeah.
sometime this summer.
Yeah.
They just leave so many open doors with this project that I think those reasons, I could not support it at this time. I'm just going to be very honest with you. Period.
Thank you, sir.
Question for Mr. Schuman. Did you guys do a natural resource survey for as endangered species?
Your microphone.
Did you do a natural resource survey to identify endangered species out there?
I'm going to ask Mr. Weinberg to respond to that. He is the environmentalist on the project. If you don't mind, I'd ask Ed to come up. Thank you.
Good morning. For the record, Ed Weinberg with EW Consultants. We are the environmental consultants on the project, and to date, there has not been one completed as it wasn't required at this point. At whatever point there is an application for actual development approval, this is simply zoning, that'll all be prepared and provided and processed through, through ERM.
Okay, thank you very much. So I guess my question to staff is, so they come back and they get their zoning and then they go do this this natural resource survey and find endangered species that might prohibit their construction of some areas, then where do they end up? So it's not only the court case, now we've got endangered species issues.
I don't see here, but they would follow the regulations of Article 14. So if there are endangered species, they'd have to follow the appropriate protocols of Article 14.
Which could affect their development of the property.
he's here. Good morning. For the record, Mark Meyer with So basically, they'll need to do that assessment at time of application for the PNV, which is the protection of native vegetation. And at that time, we would refer them to, if there were species on that site, we would refer them to the applicable regulatory authority, which if it were wood storks, it'd be either FWC or the United States Fish and Wildlife.
And that would affect their...
They would have to go through
that
their
affect
process.
how many units per acre they may have to set some aside or something, so it affect how they construct this?
They would have to go through their process. That's really all we would refer them.
Very good. Thank you.
I'm I guess in agreement with Sam even more so. We have had applicants come before, and while we understand, okay, that was not part of the process of what was needed today, we've had applicants come forth and they've done that because they know that their situation, so they've got the environmental reports, they've covered their bases. And so, I'm still, like I said, I'm with Sam. I'm not in favor of supporting this at the moment based on now. That's in addition to, what Sam had said, because even though I understand and respect the judicial process, I understand and appreciate all the work that staff has done. But it's still, if the deed and, if that is turned over, Mattamy could have, it's going to be a hot mess. If you've already started to dig and people have started to, I've bought this home, that's just opening up a whole other Pandora's box for me where you could wait. It's too big a project, in my mind, to go ahead and approve that without certain things being taken care of. That's my position.
I want to add to that, what she just said also. My concern is that you've never really, neither party has given each other the opportunity, or should I say, given each other the time to talk to these residents. They may not have wanted you there because they don't want to, as their attorney says very eloquently, open the door to saying they're consenting in some way just by the fact that they met with you. I get that. But on the other hand, they're also here telling us the reasons why they won't go along with it. So what she says is a hot mess. I think it's a bigger mess than you know. And I think for that reason, and what my other constituents have said, this project needs to be put on hold until you've resolved your legal issues. That's my opinion. Period.
Yeah. And for the record, I did go and see the area. So for anybody, and a lot of us do our due diligence prior to, if we're not already familiar, we do go to see the sites. Right. Okay, thank you.
So I would have one more question to the petitioner, the agent. Would you prefer a postponement at this point?
I was just gonna. That's what I was walking back there for. Let me figure out what we're gonna do, sir. If you give me a second, thank you.
You have 2 minutes.
He's already used them.
Commissioner Sauer, did you have any? No? Okay.
Mr. Beatty, you asked a very important question. I just spoke to the applicant and the attorney representing the applicant, and we would prefer for a vote today.
Okay, that makes that easy.
Yes,
I'll
ma'am.
make a motion.
I was going to.
Too bad. A motion to deny approval of a development or amendment to, my glasses, otherwise Sherry will complain.
Exactly.
Deny approval of a development order amendment to modifying the master plan, add units and add access points subject to the conditions of approval as indicated in Exhibit C.
Second.
All those in favor?
Aye.
Opposed?
Thank you all for your time today. We appreciate
I
it.
would like,
Mike,
Excuse me. Excuse me, please.
Don't.
Please.
No,
Please don't. Thank you for coming. Please don't, though.
I was going to say, when the board votes denial, you need to state the kind of the basis for the denial, which provisions in the...
Excuse me, please. Excuse me.
Doesn't meet all of the criteria,
Because it does not meet the...
My motion was for all, the entire...
So what you're doing, you're recommending denial that they did not meet all criteria of our standards for a development order amendment.
That's what
Right.
my motion said.
Can you please elaborate, the motion maker, which standards you believe?
You want to make the motion, Sam. There you go.
Whatever makes your boat float. I think what we're trying to say is that we're denying approval. And as Bob points out, it's the points that they're indicated in Exhibit C.
There's
We're saying
That
no to
doesn't
all
meet
of
the
them.
standards,
specific standards of
criteria.
approval.
Doesn't meet...
You believe what you're trying to say is they haven't satisfied that there's
They haven't shown...
on all of them?
Well, we would have to go through each and every one of them, if that's what you like.
What is the number of those standards?
Yeah.
could you just say A through 8?
Okay.
Yeah, okay. A through H. There, that's good. Can we just do that?
Okay, I just want to, Mr. Caliendo, so the first one is consistency with the plan, the comprehensive plan. So you're saying that is not consistent with the
We
comprehensive?
don't feel like, I believe we're all saying that we don't think it does at this
Okay.
point.
Okay, and then
Let's
the
just go down each one.
consistency with the code is the next one.
Well, we don't know. We don't know if they have because they haven't done some of their studies that we would have liked to have seen.
Okay, and then the next,
Sherry, you should have done this.
You said you
Too
wanted
late.
to do
I
it.
know, okay.
where's the next one? Okay, the next one is compatibility with surrounding uses.
All that,
No.
we really don't think they do.
Design minimizes adverse impacts.
We don't feel like they do.
Okay, design minimizes environmental impact.
We don't know.
They
that.
haven't.
We don't know.
Okay.
We don't know that. We haven't had the studies to prove it.
Development pattern is logical, orderly, and timely.
No, based
No.
on the fact that we don't have the
We have-
report.
We don't have support, right?
Okay, it doesn't comply with adequate public facilities, meaning,
I don't think they've proven that one way or the other.
and then the last one is change conditions or circumstances, that they've demonstrated that there are
They certainly
changes.
haven't done that.
Okay.
Can we?
Wendy, for bailing me out there.
Go ahead.
Okay, so do we need to repeat that with
Yeah, if we could just have a
clarification?
motion
Oh, okay.
encompassing all of that.
Motion being conclusive of the A through.
Okay.
Yeah.
I don't think so. My glasses back on. I should have let Sherry do this. Okay. How do you want to reword this? Because the way I did it was we were we were doing with the
So
denial.
I think what you're trying to say is that you're recommending denial of the development order amendment to modify the master plan, add units, add access points, because of that they do not meet the 8 standards of the code for a development order amendment, as stated in the ULDC Article 2B.
I reiterate exactly what Whitney said.
What she said.
Yeah, very good, Whitney. Thank you. Always bails me out.
So Sam made the motion, and the second was Ms. Scarborough, and then call the question.
Yep. All those in favor?
Aye. Aye.
Opposed? Well, no, we're in favor.
So that was pass of the denial 7-0.
Yeah.
Correct.
Okay, we have the last item on the agenda we postponed to next month. So we are at the end of the agenda, and we are under comments. And so I think the first is the county attorney. So Bob, do you have any comments?
Just want to thank the board for working with you over the years, because this will be my last zoning commission meeting, because I'm retiring on the 1st of March, right? So.
Oh, sorry to
You
hear
said that last
Well,
year.
congratulations.
Congratulations and thank you.
Happy retirement.
Right, and Bob's been with us for about 33 years and has won a ton of cases and has given us always great advice. So sad to see him leave, but Scott down there will be taking the reins, so we can blame him and all the new things that come up. So, but appreciate your service, Bob.
Yes, thank you so much.
Thank you.
It's been a pleasure.
Maybe
Happy
you'll grow
retirement.
hair now that he's gone. Look at the hair he's got 35 years later.
Okay.
Zoning
Any other-
director?
I just want to say I want to thank Bob for many, many, many years of partnership and planning and zoning, and I will miss him more than he knows. Thank you.
Thank you, Bob.
Planning director, Robert Bryan.
I'm not the planning director, but also I would like to echo Bob's well wishes for retirement, and he will be greatly missed. There's huge shoes to fill, Scott.
Bob assured me that his phone will be on and available during these meetings.
I'll try to keep my questions less difficult than I did for Bob.
Ramsey, did you have anything else?
No, that was
Okay.
it. I'll
And then-
add, instead of his phone being on, he'll also be on Zoom, so even easier.
Bob, we know of a place you can play golf for the moment. But
Exactly.
And then if the commissioners have any comments, that's the last thing on the agenda.
Yep.
No.
Any comments?
No.
No? Okay, thank you. Thank you, staff.
Valentine's Day.
May motion to adjourn.
Yep.
Second.
All in favor?
Aye.
All right, thank you.